for this hearing. The special magistrate is empowered under Florida statutes and the North Miami Code to hold code violation hearings. The purpose of this hearing is to determine if a code violation exists at your property as seen by a code enforcement officer of the city. If the city is not able to prove its case, then I will dismiss it and you may leave. These proceedings are being recorded, so all persons who are speaking, make sure that your testimony is clearly audible. And when you give your name, if you can, also please spell it so that we have it for the record. If English is not your primary language, then please inform me when I call your case. We have interpreters who will assist you during the proceedings. When your case is called, the property owner, agent for the property owner, should announce your presence, and you and any witnesses that you may have should also be announced. When asked, please speak directly into the microphone and state your mailing address and your relationship to the property. If you're not the property owner or an attorney representing the property owner, then you must present a power of attorney or affidavit to allow your testimony to be taken on behalf of the owner. For new cases, you will be asked for the record if you're aware and understand the violation that is being heard today, and if you understand what is required to resolve the violation. The city will present its case first, and then the property owner will be given an opportunity to testify on their behalf. You can bring forward witnesses, you present evidence, and you may present photographs and even cross-examine the city's witnesses. Following the case presentation, I will issue findings of fact. If I find that a violation of city codes exists or existed at your property, then depending on the case, I will set a compliance or an abatement date for the violation to be resolved. Or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation and a daily fine amount that I may impose at a future hearing if the violation is not resolved by the abatement date. If I find sufficient cause to postpone the case, I will table it or continue it to a later date. If you do not agree with my findings of fact or my ruling, the property owner may appeal my administrative order to a circuit court in Miami-Dade County. An appeal must be filed within 30 days of the date of the signing of my administrative order. In accordance with Florida law, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person shall have a transcript or a verbatim record of the proceedings. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant. And it is recommended that persons who plan to appeal their case should provide their own court reporter of this proceeding. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release. At this point, I believe we turn it over to the clerk, or do we do the Pledge of Allegiance?
Pledge of Allegiance, yes,
Okay.
correct.
All right, so let's do the Pledge of Allegiance.
Please put your hand across your chest, please.
to the flag.
We can't hear you. I mean, we can, but it's there's kind of like an echo there.
Okay, there's no earphones up here. Do you need me to speak louder, or what do you need?
There you go.
Okay.
Sorry. Perfect. Thank you.
Okay, no problem. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Magistrate, if I may, so there is a tiny situation. We don't have any translators on this meeting today.
All right, so for Creole or Spanish also?
No translators at all.
Okay, so for those that will need a translator, we may need to table those cases.
Yes, what's the name? Attorney Bob Murray was just letting me know that all those cases, that if they do need a translator, then we will have to table all those cases. So I guess once that they get to us, then we'll go, I guess, one at a time.
Okay.
Sorry about that. Okay, Officer Carter, my apologies. I just wanted to give the heads up.
Okay, no problem. So we're going to swear in the officers. Okay. Can you guys cut on your cameras, please?
Okay. Perfect.
Can you see everybody?
Yes, I can.
Okay.
Okay. Please raise your right hand. If you are giving testimony today on a case, please raise your right hand as I issue the oath. Yeah. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you.
Thank you. Well, since there's no translators today, can I read my script, I guess?
Yes.
Thank you.
By the way, I can see me now.
You can?
I don't know what I did, but I can see myself. That's good.
I'm glad. All right.
I wanted to show you that I'm wearing a suit. That's all. Okay. All right.
Thank you, Magistrate Smith. Good morning, and thank you for participating in today's special magistrate hearing. I will review the process by which today's hearing will be conducted. Make sure your device is always muted unless you're giving testimony on a case. If you're using two devices to participate in today's hearing, be sure your audio is only enabled on one device. When your case is called, if you are signed into Zoom, you will receive notification giving you access to audio and video so that you may give your testimony. If you're physically at City Hall and wish to give testimony, you must sign in with a code clerk and await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the code compliance office to be provided with access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click the raise hand button to be acknowledged. Before giving testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter using during your case, let us know. As we stated before, this meeting, there's no interpreter, so just let us know, and then we might need to table your case for the following hearing. Your magistrate, that concludes the instructions, and as of right now, I don't have any amendments for today's agenda, but I do have the abatement dates whenever you're ready.
All right, I was going to ask you about amendments, deletions, additions.
No amendments so far. I only have the abatement dates.
Okay, so tell me what those are.
Okay, so for 30 days is November 5th, 2025. 60 days, December 3rd, 2025.
December 3rd?
Yes, 2025. and 90 days is January 7th, 2026.
All right, are we ready?
We are ready. Give me one
All right,
second.
so let's call
Let's
call the first case.
Okay. So first case is case number 24.
Hang on one second. I'm getting
Sure.
some noise.
Not 24.
Okay, I'm back. Go ahead.
I'm just letting
What case are we calling?
case number 24.
21?
24.
24.
Oh, there she is. I'm sorry. Hi.
Good morning.
I'm so sorry. Good morning. How are you today?
How did I know that case number 24 would be the first one?
Did you?
I knew.
Okay, there we go. I'm
Okay.
sorry. Let me share. I'm trying to share my.
I reviewed the file, and I'm very familiar now with having read the file. I'm very familiar with what the issue is, but nonetheless, I'm going to ask the building official first to weigh in on a brief history of how we got here, and whether or not the building official has any recommendations. Mindful, in order to save time, I've reviewed everything that has been provided by Ms. Kozlowski. She did a good job of putting the case in a very simple, easy way for me to understand it.
Wonderful. And I do have an update when appropriate.
Yeah, there's some update information that I'm going to ask you about, but let's for the
Let
record.
me read the case.
Let me have the inspector.
Let me go ahead and read the case first, and case number 24.
Yeah, go ahead and read the file. Yeah, read the case number. Tell us who are the parties, and then I want to hear from the building official.
Got it. So case number 24, Mariners Bay Condo, FYBRR 2021-00176. The inspector for this case is Ms. Shani Pressy. Ms. Pressy, it's on today.
Okay.
And I believe our building official is also on today.
All right. So let me hear from the city on what this case is about.
Good morning, sir.
Good morning.
Ms. Mashir, we can see you.
My camera is not working. I apologize. Yeah.
All right. If we,
Yes, sir.
Madam City
Ismail?
Attorney, hang on one second. Madam City Attorney, do we need to see the witness?
It would be preferable.
Yeah, I would think so. Anybody else from the city that is visible that can?
Ms. Shani Pressy, is she
All
on?
right. Why don't we hear?
There
Why don't
she
we hear
is.
from her?
Ms. Presti, are you able to go to the
Yeah.
building official's office and help her?
Yes,
with
I was
her-
trying to unmute. Good morning. How you doing today?
Right. Can we see your face, please?
Let me pull my camera down a little bit more. It's
There you
better?
go. Yes.
Okay. Good morning, everyone.
Good morning.
Good morning.
Ms. Presti, are you able to go to the building official's office to help her with her camera?
Camera? Yeah, give me 1 second.
Thank you.
Ms. Kozlowski, I don't think we've ever met, but I believe that you have a father who's a realtor?
No, no relation there. I'm with Shubin Law Group. I don't know if you know John Shubin.
Well, I know Shubin and I know Bass, and I've watched them over the years.
Okay.
Are they no longer together?
They are a separate operation now. It's been about 2 years of Shubin Law Group, and we now have
Okay,
offices.
so you're with John Shubin.
I'm with John Shubin.
Okay, and just so that I get it clear, you are representing the condo association and their board, is that correct?
That is correct, Your Honor. I'm representing the association today and also represented them during the land use proceedings.
Okay, is there anybody that's going to testify for the developer?
No, not this morning. It's just me here on behalf of the association, but I do have an update from Continuum.
Okay, I'll ask you about that. All right, building official.
She's there. She's where Mr. Christopher Colson sits. We can't hear you. Is that me? Because I can't hear you.
I don't know if she's speaking with us, but I don't think she.
No, we can't hear you, building official. I believe they already fixed the camera in your office, so you might want to go back to your office.
Can everybody hear me?
Yes, apology about that. There's something wrong with my camera and my mic too. So anyway, Your Honor, this case is a 40-year recertification case, and we don't have any action happen to about it because we've been told that they're going to be demolishing the building. However, until that happens, the case is still going to continue. Unless they kind of find an agreement with the city through the attorney office to see that they are intended to demolish the building, this is the only way I see it out of this situation.
Well, I think I have a role to play as well. Anyway, this started back in 2029. I'm sorry, 2021.
2019, sir. Yes.
2021. So they were supposed to file in 2021. They did file some paperwork, correct?
Yes.
The paperwork agencies, correct?
Correct.
Did they rise to the level of a life safety concern?
No, sir.
Okay. Are there people living there?
Yes, sir.
And my understanding is that the 45 unit owners, or how many are there? 47?
46. Yeah.
Okay. That they have all sold their condos to a developer. Is that your understanding?
Yes, sir.
Okay. And they're still there, and they went through some land use approvals with the city, correct?
Yes. Yes, sir.
All right. And they changed the land use development regulations. They did some text amendments to the code. They were allowed to go up to, I believe, 238 is allowed. They're going to 217 on the heights. They're going to have be 267 units. I'm taking away from your presentation, Ms. Kozlowski, because I understand the lingo. I've done this, and I also understand that the city has granted conditional use approval to build the building. Is that correct?
I am not aware of this part, sir, yet.
Okay, I've seen the resos, they're in the file. And so your position as building official is that they have to comply, or else they're going to face some fines, right?
Yes, sir.
Okay. Assure me of one thing, though. I saw an old engineering report that said that the property is not a life safety issue, that people can still live there. It's not subject to a red tag. Do you agree with that?
Yes, sir. However, until we reach an agreement or until they do any permitted application to do the demolition itself, we would like very much for that same engineer to give us a safe to occupy letter for the people who are occupying the apartments at this moment. And maybe they can reach out to the attorney office to see if they can make an agreement with the city to see when this project is actually going to be coming off the ground.
Okay, I'll get to that. I'll get to that. And yes, I agree with you 100% that we need an updated affidavit from a licensed, competent engineer that the property is safe to occupy, that there are no life safety issues on the property effective tomorrow. Otherwise, the building official in her authority or discretion can red tag the building, and unfortunately, everybody's going to have to vacate. We hope that doesn't happen, but that is the authority of the building official, as well as I would encourage her, if necessary, it's within her power to take the file to the unsafe structure board
to the Miami-Dade County. Yes, sir.
And let because I'm not an engineer, I'm not a building official. I don't know when and if a property becomes unsafe for human habitation. I don't know when these folks are going to ultimately leave the property. Hopefully the project can be expedited and things can get done quickly so that we won't have the issue. I agree that we should not impose hundreds of thousands of dollars in costs if the property is going to be demolished in a relatively short time. So I'm gonna ask the property owner to brief me on any recent developments. I would like to know right off the bat whether you have plans, specifications, working drawings that are ready to be filed with the city for beginning of construction, and also the whether or not you have a demolition permit. Somebody's talking, please. Silence.
Thank you, Your Honor. Again, for the record, Leanna Kozlowski with Shubin Law Group.
Yeah, speak up a little bit because I'm having trouble hearing you.
Sure. Is this any better? Good morning.
Yes.
So just for the record, Leanna Kozlowski with Shubin Law Group. I'm representing Mariners Bay Condominium Association, Inc. The update that we have for you, we were able just yesterday to get a updated safe to occupy letter from the engineer of record. The letter makes clear that although there is structural, quote, there is no danger of imminent structural collapse and the building is reasonably safe for continued occupancy. This was signed and sealed yesterday, September 30th. I can provide that to the building official as soon as this meeting concludes. In
Yeah,
terms of
I would hope that if you can do it today, great. If
Yes.
not, my order, which I will enter, will say that you have to provide that within 48 hours.
Understood. That will be done right away. The other update is we are scheduled to close with Continuum in 29 days, October 30th. So the building has already filed for a conditional termination. It was dependent on obtaining that last city approval in January of this year. After the closing, there is an agreement between the developer and the association, which we're grateful for, where the residents will be able to stay for another 8 months. After that point, the building will be vacant, unoccupied. So we anticipate, let's say 9 months from today to move forward and completely turn the building over to Continuum.
And the Continuum, is that the same entity that built the Continuum in South Point and also is building in North Bay Village?
Correct, Bruce Eichner.
Is that the Eichner family? Are you dealing with Mr. Bruce Eichner, or are you dealing
Correct.
with the daughter?
Both of them. Both of them have been involved in this process, and it's been a fantastic collaboration, I'd say. They've been very accommodating to the unit owners, and you know, it is an important component that after closing, we have some time for the residents to relocate. So that's why
you have to go through the building permit process, right?
Continuum will, yes.
Yeah, Continuum will, and they haven't started yet because they're not the owners.
Right, they're waiting for that October 30th closing date. 29
and then approximately how long after that will they be demolishing? Right after the 8 months?
I think that is the plan. You know, they're ready to go. They wanted to move forward with this probably 2 years ago, but it has been a layered process. So
okay,
yeah.
is the purchase and sale contingent on any city action?
That's already occurred. The January 14th, 2025 approval was the final approval that was needed. There was an appeal.
Yes, I was going to ask you about the appeal. What happened?
That's now been quashed. So there are no further conditions to closing.
Okay, okay. And the appeal was by a neighbor?
Correct.
Some complaining about the height or something?
Right.
Okay, typical process.
Yes.
Somebody doesn't like the height or doesn't like the density, and that has been dismissed with prejudice.
Correct.
Okay. Now there's some issues that are potentially life safety. One of the things that I read was that there's no guardrail keeping cars from landing in Biscayne Bay. Is that still a concern? Or do you know?
The only, you know, the bulk of what we're dealing with was concrete restoration work. I'm not aware of a guard. I've been on the property. I'm not aware of a guardrail issue.
Okay, I saw a picture of a bush that is supposed to divide the parking lot from the property, from the water. Okay, so that was one issue that I had a concern about. I also read about some issues with the balconies. There's some cracks in the balconies. Are they accessible to the property owners?
Yes, I mean, these are personal balconies, but again, just going back to the letter from our engineers, none of this is a life safety issue.
Okay, so we're not going to have people going out to the balconies and falling down to the ground?
No.
Okay, I would urge the building official to make sure that the balconies are safe, and that if the balconies are not safe in any way, shape, or form, then they should not be accessible to the to anybody, a guest or a property owner. So Madam City Attorney, do you have anything to add?
No special magistrate.
Okay. So 8 months takes us to when?
And it would be 8 months from closing. The closing is
The closing is
October
it,
30th.
yeah, but then at the closing, the closing is on October 30th.
Correct.
Okay, but then the property owners can stay there for an additional 8 months. So that would be November, December, January, February, March, April, May, June. They'll be there through the end of June, I suppose.
Right.
Okay. And by now the condo association has been terminated.
It's a conditional termination. With the closing, it would be official, and then you would go through a winding down period.
Okay, and I understand, and yes, you have a question? No, okay. There is no problem with funding. The fundings, the continuum has the funds?
Yes.
Okay. Any issues with the mortgagee, the mortgagor? No,
No, I mean, there was some changes with the funding, and so that's why we had a rescheduled closing date, but all of that's been worked out, and so we are looking forward to the 30th. There should not be any issues.
Okay. All right, so my ruling in this case will be as follows. Based on the review of the file and in
Your Honor,
yes.
I have to mention something regarding the safe to occupy engineering letter. It has to be done every 180 days. So if they're gonna be, yes, so if they're gonna be staying there 9 months, so we need the one that she's gonna be submitting tomorrow, and after the 6 months from that day, we need another additional one.
Okay, I'm glad you brought that out, because one of my rulings will be that the building official still retains any and all authority of a building official under Florida statutes and county code sections. So at any point, Madam Building Official, you're free to make any requests, requirements. You can even red tag the building if in your discretion that is necessary in order to ensure the safety of the residents. That in any way take away any authority that you have under the Florida Building Code.
Thank you, Your Honor.
But what I'm going to rule is that based on the testimony and the evidence that I've reviewed, and having listened to counsel, I will rule that the violation of the county code section in question, as well as the city code, for which I have no authority to change or modify or add to the code. Let me get the code section. Oh yeah, so the 40-year recertification ordinance in the code is 5-37, and the county code section is 8-11F, and it talks about shall. You shall. I have no authority. I have no authority to change the or give you additional time beyond what I'm going to give you, and that's it. I have to follow the guidelines set forth in the 40-year recertification and in the code, in the city code and the county. So I'm going to enter an adjudication of guilt because we haven't, the property owner has not filed the necessary documents and shown the necessary paperwork to get a final approval from the city. So I find the property owner guilty of violating the 40-year recertification section. And this is something that goes back to 2021. So it's been quite a while. I will give the property owner until the closing for sure, which is set for October the 30th. It's kind of difficult because we're now dealing with a new owner that's going to take over on October the 30th or November 1 or whatever the date is of the closing. So I will require the new owner, Continuum, as part of my ruling to come back to me on November 5th, it's 30 days, so that I can issue an order that is binding on them. I assume they were not served with a notice for these proceedings, but as far as the condominium association and the property owners, if they vacate within 8 months, but no later, there will be no fine. They have 8 months. They have 8 months to continue residing in their condominium as per the agreement. After 8 months, the fines will be for the condominium association $1,000 per day if they stay beyond the 8 months. Then, as to the continuum, they'll have to come back. They'll have to appear before me on November 5th so that I can make further orders. But again, if there's no compliance by June of next year, if the property owners don't vacate, I will be fining the association, even though it doesn't technically exist anymore. It may be that the property owners will be responsible because there is no association. But in any event, I will rehear that in 8 months to make sure that everything, that they've vacated the property and the property is ready for demolition. I know this is complicated. This is the first time we've ever had a situation like this. It's happening more and more in Miami-Dade County, so we better get used to it. But I will, even though I have adjudicated the property guilty, I will not be immediately imposing fines until I hear from the Continuum folks on November 5th. They're the ones that need to be cited. And I don't want some low-level employee coming up and giving me a lot of nonsense. I'd like to hear from one of the owners. Don't need to hear from Bruce Eichner. I can hear, the daughter or somebody, an officer, director can show up and explain to me what they plan to do to keep the property safe, because any order that I enter today against the condo association will be a worthless piece of paper come October the 30th. So I really need to hear from the Continuum on November 5th. Does that make sense? Or any questions from the building official, the clerk, anybody else that may want to? Ms. Kozlowski, what do you all think?
I think this makes a lot of sense. And I just want to say we are in close communication with Continuum and their general counsel, David Fishman. I suspect he is going to be the one, maybe with someone else from Continuum, who would come back on November 5th. But I'll make sure to relay all of this information. The only other piece, of course, is, you've ordered that within 48 hours, we provide that safe.
Yeah, my order will require providing the building official with any documents that she requires to make sure that everything is safe. And I am in no way, nor can I, interfere with her duties under the Florida Building Code. So if she decides tomorrow morning to red tag the building, there's nothing I can do about that. If she decides, to make the balconies inaccessible or to have a temporary fix just to make sure that concrete doesn't fall on people's head, that's within the discretion of the building official.
Thank you very much, Your Honor. And now that she's going to be submitting that letter, we're going to have to request from the professional engineer who issuing the letter to add something regarding the balcony and the safety of the balcony and making the balcony not accessible. So we're going to ask for advice.
And I often don't, I question why these 40-year recertification cases come before the special magistrate. I'm happy to hear them, but I can't do anything that intrudes on the building official's authority. So she can overrule me on a lot of these things. But what I want to do is make sure that the Continuum understands what happens after October 30th. Hopefully you'll have a closing. If the closing is delayed for whatever reason, Ms. Kozlowski, I'd like you to advise the city if there's a delay, and then we can deal with it. I've never seen a closing that takes place exactly on the same day as planned, but hopefully here it will happen.
We'll be in regular communication. We appreciate the city working with us, and we'll move this forward as expeditiously as possible. Thank you.
Yeah. Congratulations on successfully getting 46 or 47 residents to agree on anything.
Right.
But and congratulations on the sale. I think the project, from what I understand, will be first class. I think the city should be excited that there's going to be a nice property there, paying taxes. There may be one or two unhappy residents living next door that may question, the height. By the way, from what I read, you actually are building within the envelope, right? Your building is below the height that was awarded in the amendment to the text amendment, right?
Correct, and it's resolving a lot of flooding issues, resiliency issues. It really is, I think, a step forward for the city.
Yeah, and also I noticed a lot of public benefits associated with the project.
Yeah.
Okay, I'm glad we're able to help you, and let's hope that the Continuum moves along quickly. They have to file plans. They have to do the demolition, and it's at least a 2-year project. So let's make sure that it moves along.
Thank you, Your Honor.
Okay, let's hear. Thank you, everybody. Thank you, building official. Thank you, city attorney. City attorney, of course, is encouraged to work with the building official, make sure that everything is complied with. If the city wants to make a side deal, that's perfectly okay. You may need to bring it to the city commission at some point, but from my perspective, as long as there is no life safety issue and it's still under the authority of the building official, I'm comfortable. But you know, by the way, the condo association has been found guilty, you know, because they have not complied with the law, and I'm not allowed to ignore the county code and the city code. So there is guilt, but as of this moment, there are no fines. We'll see what's happening on October the 5th, but as of this moment, there are no fines. Okay.
Thank you again.
Bye. Next case.
Thank you, Magistrate. The next case is gonna be case number 19. My apologies, let me share.
Did you say 19?
Yes, sir. Case number 19, Jonathan Bloom.
By the way, I'm seeing the agenda in front of me.
Yep, you want me to take it out?
Yeah, take it out so I can see people and hear people better. When we get to the case, then you can open the that particular case only, not the whole agenda. Okay, so you say number 19?
Case number 19, Jonathan Bloom, CETRE 2023-00028. This case was found guilty by Magistrate Casu. Must abate by June 16, 2025. A fine was set at $250 plus 100 cost assessment. We have Inspector Gabriel Morales is the inspector for that case, and we also have the city arborist online, Ms. Marisa Magrino.
All right, let me hear from Gabriel Morales.
Good morning, Inspector Morales for the City of North Miami. I inherited this case from a previous Inspector Gennaro Murillo. This case was issued back in April of 2023. This is for a tree removal at the property 728 Northeast 123rd Street. It was, as mentioned, it was found guilty by Magistrate Casu, May of 2025. Per my final inspection on September of 2025, the case is still in violation. No compliance has been met, and notice was posted at the property for 2023, but that's all they did. They didn't proceed further.
Which means what? That they were required to seek
a permit, and the permit was never closed. It's just still pending there as applied. So it wasn't approved.
It was not approved, so they knocked down the trees without a permit.
Correct.
So what happens now? Do they have to put another tree, or do they get fined, or what remedies do I have when something has already happened? What am I supposed to do?
So the previous arborist gave Mr. Bloom 3 options to either plant trees on site, 1 native at a minimum of 10 feet, 2 trees, minimum height 6 to 8 feet tall, or pay $600 into the city's tree mitigation fund. And that was back in June 2023, and he hasn't done any, he hasn't fulfilled any of those options, and so it's still an outstanding open permit.
So if the property owner does any of these things, then he would come into compliance?
Correct.
All right, is the property owner present?
No, sir.
Okay, the property owner is not present. Okay. All right. based on the unrebutted testimony of the city's code compliance inspector Morales, and the photographs and the evidence I've looked at, and having heard from the arborist, I conclude that the property has been out of compliance since the compliance date of June 16, 2025, which set the fine at $250 plus a cost assessment by my other magistrate, Kazoo. So based on all of that, I ratify the fines accrued to date and assess costs in favor of the city. The fines shall continue to run on a daily basis until there is compliance. So the property owner must pay the $250 as of June 16, 2025, and going forward, also $250 a day until there's compliance. At this point, the property owner is directed to discuss with the city potential mitigation as discussed. And the city certainly is within its discretion, may modify the fine, but that's up to the discretion of the city. So is that what you're seeking?
Magistrate, at this stage, he's been giving us different reasons why he can't move forward. Some, I think initially with Allison, he was discussing that he still has a site plan in process for the, new house or addition, and he can't plant trees, and that went on for a while. And I think he's given additional reasons recently to staff, not to me, but to other staff, why he can't follow through with mitigation. So I just don't know if working with him is, it's been working for us. So I think maybe just having him pay into the tree mitigation fund instead of trying to have him plant trees on site would probably be an easier route to go, because he's just not working with us and communicating.
I'll tell you what to do. You stop any further negotiations. You stop listening to any excuses. The fines that I have imposed will be the subject of a lien on the property. So whatever the amount is that has accrued to date, plus a daily fine of $250, will be part of a lien. Okay. And that lien will be filed by the city attorney's office or the clerk or whoever does the lien work, or the finance department. File the lien, and I bet you that you'll hear from him at some point. Before he can get a building permit, he's going to have to pay for the lien. And it may be that the lien is $50,000 by the time that you hear from him, but that's the hammer, that he can't do anything with that property. He can't even get a loan. He can't build anything with that lien on it. So lien him. That's what the statute gives you the right to do on all the violations, on all the fines that have accrued. Now that I've ratified the fine, lien the property. And you don't have to keep talking. He'll come to you. You won't have to go to him.
Okay, sounds good. Thank you.
Okay, all right. Next case.
Next case is case number 33 and 34.
Okay, any?
Mr. Robert Waxman, sir, I keep sending you to be promoted. If you can please accept it. Would you like me to read both cases, sir?
Please.
Case number 33, Ricardo and Luis Costa, CEBPR 2025-00265. This case was found guilty by Magistrate Casu, was obeyed by September 15, 2025. Fine said at $250 plus $100 cost assessment. Case number 34, Ricardo and Luis Costa, CEMIS 2025-00226, found guilty by Magistrate Caso, must abate by September 15, 2025. Fine set at $250 plus $100 cost assessment. The officer for both cases is Mr. Jonathan Lemestri.
Okay, anybody present? Have you read both cases?
I did 33 and 34. I do have Mr. Robert Waxman. I'm not sure if he's on. We cannot see you, sir. We have to see you.
Okay, can you hear me?
We can hear
Yes.
you. We cannot see you.
Okay, let me start video. Let's see.
All right, we see you.
Okay.
If we may, Mr. Waxman, are you the owner of the property?
No, I am not. I am a very interested party. I'm the next door neighbor. And yeah, well, I'm sure with the volume of cases the magistrate hears, he may have forgotten, but we had hearings back in 2023, in March of 2023, involving the same property owner. And I was also an interested party at that time. I want to stress that. Go ahead. You want to stop me?
Yeah.
No. The reason we have to stop you momentarily is, number one, I want to make sure whether or not the property owner is present, because
Okay.
he's got a due process right to be heard. And number two, any witnesses that may testify will need to be sworn in. So I still need to make a finding that you have standing to testify. I probably will allow you some time, but I want to learn a little bit more about the case, because I was not the prior special magistrate. You may have appeared and you may have testified in a case where I had nothing to do with it. It just so happens that it landed on my desk, and it was heard by a different special magistrate. So I want to hear, first of all, from the officer to brief me on what the case is about, and then we'll figure out from there. First of all, is the owner here? Is the owner present?
No, he is not.
Owner is not present. Owner did not follow the order from the prior magistrate. Okay, let me hear from the inspector. Put everything you need on the record, and then we'll figure out what to do next.
Yes, sir. Good morning, everyone. Neighborhood Service Inspector Jonathan Lemestri, and this case is being heard for the second time. Let me start from the beginning with this case. On June 26, 2025, I opened a notice of violation in regards to case number 33 for a generator being installed on the property without a building permit on file. I posted the notice of violation, and I also mailed the notice of violation to the property owner via property appraiser. The property owner has failed to comply by removing the generator or applying for a permit to have the generator on the property. The violation did go in front of Magistrate Kazu, and they had to abate by September 15. The fine was set at $250 plus $100 cost assessment. So they had an order to comply. And as of September 14th, 2025, which was the final reinspection date, the property owner failed to apply or obtain a permit for the generator on the property or remove the generator from the property.
Okay, there are two cases.
Yes.
The first one is for doing electrical work on the generator.
Correct. So they installed the generator on the property and they did electrical work. Madam Clerk, if you could put the photos of the generator.
I've seen him. I've seen him.
You've seen him. Okay.
Yeah.
Yeah. So they did electrical work with the generator without a permit on file. We spoke. I did my spoke to the building official and to the building department, and yes, they are required to have a permit to have the generator on the property. And yes, they did that without a permit. Correct.
Okay. And the second violation is for what?
So
what's the difference between the first violation and the second violation?
So for case number 33, they installed the generator without a permit on file, and for case number 34, the generator is stored on a trailer in their driveway without city approval. So they need to get city approval to have a generator stored on their driveway, let alone on a storage trailer on the driveway. They don't. It's not allowed.
Okay. So the first violation is the permit issue, which falls under section 532.
Correct.
Second generation is more of a land development regulation violation under 29-5-107. Correct?
Yes, sir.
That's why, because they look similar. I didn't understand why we needed two violations for the same thing. Now I understand. Okay. So since the property owner is here, I'm going to basically ratify the fines and keep the fines running. And I don't know what more, Mr. Waxman, do you still want to say something?
Yeah, I do, because...
May I, excuse me?
Yes, he has to be sworn.
Yeah,
Okay.
Thank you. Sarah, if you can please raise your right hand. Thank you. Do you solemnly swear or affirm the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Go right ahead. Tell me what's on your mind.
Okay. I want to stress, first of all, my only concern in this matter is safety, which you haven't heard a word about up to this point. There's something that's being overlooked, and you need to take a look at, I think it's page 9. I had sent a picture, I had submitted a picture, through the appropriate channel. This all actually started about 2.5 years ago. Crystal Patterson, who is the head of code enforcement, which is now called Neighborhood Services, came to the street to see firsthand a code violation that was going to be heard by you in March of 2023. Okay, that's why I thought maybe, you might have some recollection that there was a hedge issue at the time. And, you ultimately decided that the hedge had to go, and the city ultimately sent out a contractor to take care of that. That's not the problem. That's not what we're here for right now. But when Crystal Patterson came to the street, she came back then to try to mediate, try to discuss with the property owner, who happened not to be there. But she saw the generator, and she asked me, how long has that been there? And I said, oh, roughly 10 years. It's been there a long time. And she left the city, I think, 2 weeks later. So, I suppose whatever note she took, whatever she had pending, may have fallen through the cracks, in the interim. So I followed up earlier this year to find out what was going on with this. My understanding is from your prior decision, there was a lien, that was put on the property. I think that lien, which has been ignored, is at least at $250,000 right now. Somebody from the city would have to verify that. So liens don't work here. What is my concern? You have a box, you have an electric box that is touching a hedge, a legal hedge, that goes from the sidewalk all the way to the back of the property, which, happens to be on a canal. Okay? If that hedge catches fire because there's a bad connection, I've got 3 bedrooms on my property that are very close to that hedge. That's my concern. We have a safety concern here. If there's a fire, you know, I've asked the city attorney, does the city have any liability here? You know,
let's not get that far.
Okay, that's fine. But I want you to understand, I'm not concerned with aesthetics. I'm not concerned with code numbers, things like that. That's inside baseball stuff. I am solely concerned with the fact that there's a box that's, you can see from the pictures, it's right up against the hedge.
All right, you've made your point. You've made your point. First of all, that matter, as much of a safety hazard as it might be, is not before me. So I can't rule on something that is not before me, because the property owner, the property hasn't been cited, the owner hasn't been cited for that.
Who takes care of that?
I'll get to it.
Okay, I'm sorry for interrupting.
I also take issue with the fact that liens are, you know, don't do anything. Well, number one, you can't, you're in default of your mortgage. Number two, you can't get a loan. Or number three, you can't sell your property, and it accrues enough money that it may even be, you know, it may be worthwhile for the city attorney to file a foreclosure. And I have done it as city attorney. I've foreclosed on liens. So you know, if the lien is, if the property is worth enough, if there's enough equity in the property, the city may want to own the house and give the house to the code department for their employees, whatever, or sell it. Mm-hmm. But nonetheless, I'm going to rule on the violations that are in front of me right now, and I'm going to ask that the building official or her representative immediately go out there and do an inspection for any kind of a life safety electrical related issue, number one. Number two, if the city deems it appropriate, then if it does become a life safety issue, the city has within its powers the right to go into the property and remove the generator at the cost to the owner. There are ways of doing that. I'm not the city attorney, so I can't, you know, decide what is best for the city, but there are options and alternatives available to avoid any potential hazard to you or anyone else.
That's all I'm looking for.
Okay.
That's all I'm looking for here.
The building official would like to speak. If you can give
Madam Building Official, please let us know I see you raised your hand. What are your thoughts?
Yes, sir. We already did this visit to the site. However, we were not allowed access to actually verify if that installation of the box is improper, is complying with the code, or even the national electric code. We could not access the property. Picture provided by other people, we're not going to be able to take it. It has to be us taking the picture, sir. So we did multiple visits, and we cannot get access to look at it closely.
There is a gate. It's a gated property. If what you're talking about is you actually have to physically walk onto the property.
Yes.
How do you get the authority to do that then? I mean,
exactly. You know, the owner has to grant us access.
Yeah, but then there's a catch-22 here. I mean, if he says no because he doesn't want that, he's got if he thinks he's got a problem here, how do we get compliance?
All right. I don't want to give the city advice, Mr. Waxman, and I don't want you to feel like the city is ignoring you.
I do.
Okay.
I do.
Well,
I do, Your Honor.
Here's what I recommend to the city. There are ways through code enforcement and through the legal process to get a subpoena to have access to the property and do whatever inspection in the public interest is necessary to avoid what I would call a public nuisance. There are ways, okay? You just have to be a little bit creative sometimes. And so I would urge that the city attorney and the building official and the head of code get together and figure out what the best avenue is to go in there and have an inspection, a lawful inspection, which would be by way of a subpoena from a court if necessary. Well, it has to be from a court. I'm not sure that the code gives me the authority to issue a subpoena, but maybe the city attorney can look at Chapter 162 and see if I have subpoena powers. I don't think so, but I do, but not in this issue. But in any event, the city is committed to looking at it, and I think that by filing a lien, we're going to get the owner's attention. And as far as your property is concerned, Mr. Waxman, you also have the authority and the right to talk to an attorney and figure out whether a nuisance lawsuit against the property owner next door to you, whether that constitutes a nuisance under Florida law, and then the court can abate that nuisance by requiring the property owner to do things. So you have rights too. You don't, you never want to solely rely on what the city can or cannot do. You as a property owner and a budding property owner who is affected by the property next door, you have rights also. Okay. So I would talk to an attorney also. It's not just the city. There's some other things you can do if you feel that there is a violation of your rights. Okay. I've represented people in similar situations, and I have filed nuisance lawsuits against abutting property owners that have done things like violate the code and what have you. All right, what I'm going to do is ask both cases mentioned 33 and 34 together, based on the testimony of the city's code enforcement officer, the photographs and the evidence presented, reflecting that the property has been out of compliance since the compliance date, the abatement date of September 15. I find in favor of the city. I ratify the fines accrued to date in the amount of $250. Assessed costs in favor of the city. The fines shall continue to run on a daily basis until there's compliance. And I also authorize the city to go ahead and file liens against the property owner.
Thank you, Your Honor.
Okay, Mr. Waxman, I try to help you because I've been in both sides, and I think I know this area pretty well. I think that between the city and maybe a letter from your lawyer, maybe the matter can be addressed.
I hope you're right, but I will also tell you this property owner has a history and a record, and it involves you, of ignoring any and all communication. I think anybody who's ever tried to communicate with him has had absolutely no success. Nothing gets his attention. That's part of my frustration.
Okay. Well, if a lien doesn't do it, a lawsuit either by the city or by you probably will get his attention. Anyway, let's move on because we've got a long agenda, and I've got to finish this meeting by 2 o'clock, so we gotta rush.
Alrighty, so we're gonna call next case number 44, Timothy and Ananiades, CEFAC 2024-00004, and I have Miss Jennifer. Okay, there they are. Good morning. If you could please, the officer for this case is Miss Shannon Sanders. Miss Sanders.
All right. The property owner is present. That's
Yes,
Jennifer.
they are there. Jennifer.
Yeah,
and Ann.
how do you pronounce your last name?
Naniadis.
Say it again.
Naniadis.
Aniadis.
Okay.
Would you like me to swear them in, or
Yeah,
you would
let's
like
swear
to
him in
hear?
right now.
Okay, if you could please rise. Thank you. Do you solemnly swear or affirm the testimony you're about to give in this proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
I do. Thank you.
You mind if I call you Timothy?
Timothy is fine.
And Jennifer? I think it's a lot easier.
It's true.
Okay. You know why you're here?
Yes, and we're surprised actually, yes.
Okay. Apparently there's some water leaking and sewage backup in units 47 and 48. I assume that this is a multifamily property?
Yeah, this is part of a condominium. It's a two-story condominium. Basically, we're on the second floor, and 47 is on the first floor. The pipe in question is a common pipe that runs through the walls and under the apartment of number 47. So my unit's bathroom and number 47's unit bathroom connects to that pipe. That particular pipe is a pipe that is the responsibility of the HOA to fix it. They determined that it was damaged. They got a permit to repair it. That was 2 years ago. Because of that, obviously, my apartment could not be used, so my tenant had to move out 2 years ago, a year and a half ago. And the owner of number 47, because she was in a litigation with the HOA, would not allow them to go in there and do any type of repair. They filed an injunction. The HOA filed an injunction. Finally, the injunction came through. At the same time, the case was dismissed back in August of this year. So now they're finally able to work on that pipe. I do have pictures. I tried to upload them because they started yesterday to work on it, but obviously it was too late for me to upload them. So at the end, my apartment is being fined for something that is not even, not only my responsibility, I can't do anything about it. It's not, I'm getting affected, but I'm not able to do anything about it.
All right, let me understand the basic facts. Do you own 47?
No, sir.
Okay, you own 48.
Yes, sir.
And the leaking, the leaking is coming from
the floor of number 47.
From 47.
On the floor. Every time I use, or she uses her bathroom, that's when the leaking came.
Okay, so the leak starts in 47.
On the floor on 47 under her toilet.
And you're underneath 47?
I'm on top of 47.
You're on top of 40. You're in 48, so you're a floor higher.
Exactly.
So how does a leak from 47 go up to 48?
It does not. I have no idea why there is a violation on my apartment when the only contribution I had to it, if I used the toilet, then it affected number 47 underneath. But I have nothing to do with that pipe itself.
All right, so for some reason, when you use the toilet, the pipe leaks from 48 to 47 below you.
I'm not sure if you can see a picture to make it maybe clear. I do have a picture here on my phone.
No, just answer the question. When you flush the toilet, the water from your apartment, from your toilet, flushes down from 48 to 47.
it flushes from 47 to the main pipe of the two units. Those two units share one main pipe.
In the walls.
In the walls.
Yeah, I understand the issue with the condominium. I'll get to that in a minute. But how does the water flow? Does it flow from 47 to 48 or 48 to 47?
8 to 47.
What?
48 to 47.
Okay, so if it flows from 48 and you're the owner of 48, why are you saying that it's the fault of 47?
Because it doesn't basically, my pipe is connected to the wall, the common wall of the building. That flows down underneath number 47, and the water comes out from the floor up into 47's bathroom. It doesn't come from the top. It comes from underneath, because the pipe under, the main pipe that goes under number 47 all the way out, it was plugged, and it needs to be completely replaced. And that's
okay. All right, I understand. I understand the situation. Okay, so Inspector Sanders, there are three parties here. You got the condo association that owns the common elements, including pipes. There is the property owner in 47, who may or may not have plumbing issues, and we don't know whether it's this pipe or some other pipe. And then you have these folks who are in 48. Do we have the right parties here? Can't hear you.
Miss Sanders, we can't hear you.
Shanna Sanders, City of North Miami Code Compliance Officer. I have all parties here involved regarding this matter. I cited 48 and 47 regarding this matter. 47 initially gave me a call when this violation was originally opened, I believe in 2023. They were having issues about plumbing. We were trying to work with them. Their lawyer contacted me latter part of 2023. Violation still occurred. We went out there in 2024 and decided to open up some violations. So to answer your questions, all parties were cited and are involved because we don't know where. Both of them are saying that both being 47 and 48 are saying that the plumbing and piping are coming from each other's buildings. I asked at that time for them to provide the city with a plumbing report, possibly call a plumber to see where the piping is actually coming from. That has not been submitted to the city. During the time of my request, more damage started happening. There ended up being a plumbing or pipe explosion that happened. Wow. That then, forced the hand of us opening up even additional violations. But all parties were cited, the condo, 47 and 48.
Okay, these folks before us today, they own 48, number 48.
Yes.
And you're citing them for violations in 47. How does that make sense?
I cited them for violation of 48. At that time, they had a tenant. We spoke, and she did at that time state that she had plumbing situations. The plumbing was backing up. And again, at that time, that's when I requested the report. So I cited 48 because the tenant at that time said she was having plumbing problems.
Are they? Was the tenant a tenant of these property owners?
Yes.
I believe so. The woman identified herself as a tenant.
So Timothy and Jennifer, did you also own 47?
No. And my tenant, maybe she misunderstood. The plumbing issues that my tenant had, that she could not use the toilet and her shower because the water was backing out of the floor of number 47. It had nothing to do with our apartment itself.
All right, so your apartment 48, you had it rented out. This was not your home.
It used to be, but not now. Yes.
Okay, so you had it rented out.
Yes, sir.
And because of these plumbing issues, that tenant vacated the property.
A year and a half now.
Okay, so now is it empty?
It's empty and unusable.
Okay. All right. I cannot, Inspector Sanders, I'm not an engineer and not a plumber, and we don't have all the parties in front of us. We don't have an expert report. Has the building official been out there?
At the building official at that time, I don't know if she's been out there recently, but the building official at that time came out there because, again, there was a big explosion. It was myself, the building official, the fire department, all parties were involved. So
Okay.
I see building department is there. Again, so maybe they can say if they've been there recently, but at that time we were.
Okay. I don't know at this point who's to blame and who's required to fix it. My understanding of condo law is that issues inside a wall, such as piping, air conditioning, plumbing, sewage, those are issues that are typically the responsibility of the condominium association. I don't know, I've heard this type of situation before where pipes get clogged and then the water goes up instead of down. To me, it looks like the responsible party may be the condo association. Is this a relatively new building or is it an old building?
It's built in 57, sir.
Okay.
And
have they had their 40-year recertification?
Yes, they did. And if I can say something, the work just started. It was delayed because of the apartment owner of number 47 would not allow the condominium contractor to go in there and repair the issue. This was resolved as of 2 weeks ago. So now as we speak, they're working in, because I was there yesterday, they're working and they're actually gave us a 2 to 3 week window before they complete the repair. Because the repair is very, almost 20 feet of pipe that needs to be they dug up the floor right now, and they need to reconnect the pipe and then call the city for a re-inspection.
So has a building permit been filed?
Yes, sir. There is a building permit. Ms. Sanders knows that, and also there is an extension. They had to file for an extension because it expired in May. So they got an extension now, and they're ready. They've been working on it.
Who's applying for the building permit?
The association.
Okay, and do they have a plumber to do the work?
They have actually a general contractor.
Yeah, they have no problem. The associations have no problems getting in there and doing the work. The condo docs allow them to do that, whether the owner of the condo wants it or not. They have the right to do that.
There was an attorney involved that, let's put it this way, for the last year and a half, it's been a frustrating issue between the association, myself, and my wife, and the owner of 47, because her lawyer would not allow the association to enter her apartment.
Well,
so that's resolved now. So I guess for the next 2 or 3 weeks, the issue will be resolved.
Magistrate, I want to jump in and answer your question. I see building department is holding up their hand. I was looking at the history of the property. I don't see a current 40-year building certification that you asked about. So I would say no, they don't have a current one, but I'll let the building department answer that as well. In addition to, you asked who's pulling the permit for the work that's done. I'm showing 47 actually applied for and obtained the permit for the work that's being done in the units.
The owner of 47 applied?
I'm showing here in the system, yes, the building, the permit was applied for in 2024 for an emergency sewer repair, and it was by unit 47. They have cases on the docket too as well, so we'll probably hear their testimony. She texted and said she's on that she's registered in, but yes, she obtained the permit. Now I don't know if what if they made an agreement and the condo was doing it through her, but it's actually she obtained it, her and her lawyer.
Well, what I'm going to do is I'm going to table this case because I don't have enough information to find these property owners either guilty or not guilty. I'm not making a decision on guilt. I'm just saying that this case at this point is not ready because I don't know, nor is there sufficient evidence that the problem is with you, Jennifer and Timothy. It could be that you did something, or that it's within your control or ownership. It may be that the pipe is something that you have control over. I don't have the condo docs. I don't know what the lawyers are saying. I don't know what the condo is saying, or Unit 47, especially if they file a permit. I'd like the city. I'd like Inspector Sanders to bring everybody in. That's the condo association, Unit 47, and Unit 48 at my next meeting, and let's get to the bottom of it. And I'd like some testimony from the city that can tell me what the source of the problem is and who owns or controls that property. If that pipe that we're talking about is within the common elements of the association, then the association is guilty. If the pipe is within the property of 47, 47 is guilty. If it's 48, 48 is guilty. And why the pipe is defective or clogged, I don't know. I mean, it's impossible for me to make a decision based on the information that I have in front of me. So let's get everybody before me. Hopefully by then they'll have the pipe fixed.
Yes.
And it may be that there's an insurance company involved too, because homeowners associations cover these kinds of damages. So it may be that the owner of 47 filed a claim with the insurance company and it's being done through the insurance company. I don't have any idea what's going on. So we'll table this until my next hearing on November the 5th. Is that my next
December? You got me confused there. I'm like, no, it'll be December.
Okay, because you gave me the the abatement dates, and I thought that was the.
No, those are the abatement dates, but your next hearing will be December.
Okay, so
December 3rd.
So let's rehear it in December, and by then hopefully it'll be fixed. Now, if it becomes a condition where you could have an explosion or a fire or whatever, the building official can go in there and red tag as many units as are necessary to keep the public safe. And I think all the owners and the condo and everybody has the similar interest in getting this thing fixed. And it's probably not just happening in these units. It's probably happening in other units as well, being that it's an old building. Which brings me back to the 40-year recertification. If they don't have a 40-year recertification, then maybe it's time to cite them for that and let their inspectors figure out what the problems are. Ms. Sanders, do you agree that if they're not in compliance with the 40-year recertification, that they should be cited for that?
I see the building department is raising their hand. I'll let them answer that.
Yes, please. Ms. Presley?
Ms. Presley, go ahead.
She's on you.
Sorry. That property actually is in compliance with the recertification. The next one is due. It's in 2027.
Okay.
I'm just picking back off for Ms. Sanders. The application that was filed was only filed for unit number 47, and that application is now expired. they will have to try to renew that permit or apply for a new one, because after 6 months the permit becomes abandoned. So either
Okay.
47 gonna try to renew that permit, and it's up to the building official, or they have to just apply for another
Okay,
permit.
so when you bring this case back to me, cite Unit 47 for an expired permit violation.
We had a conversation yesterday with, and their understanding that the permit needs to be renewed before any work should be done. If it's not done before the day is out, I will cite them accordingly.
Yeah, if they haven't at least filed something within the next 10 days, then cite them for expired permit, and let's see what happens when it comes before me.
I can, and if we can, Magistrate, I'm going to ask in Ms. Alvarez if you would agree as well. Seeing that we have this case before us, can we go ahead and call 22 and 23 right behind it so that we can get maybe the same adjudication? Let's get the testimony of 47
22
on
and 23
record.
are already next. They're waiting for us to finish with this case.
Okay, but thank you so much.
Okay, as far as I'm concerned, this case needs to be tabled. So let's bring it back with all the parties together, including the association. Make sure somebody from the association is present, because if they're not present, they're going to be cited. Okay? All right, next case.
Thank you. Next case is case number 22 and 23. Case number 22, Maria L. McLure, CEBPR 2024-00070. It was found guilty by Magistrate Casu. Was abated by September 15, 2025. Fine set at $350 plus $100 cost assessment. Case number 23, Maria L. McLure, CEBPR 2025-00288, and that case has not been found guilty before. The inspector for both cases is Ms. Shanna Sanders, and we do have an attorney, Mr. Grant Barrows. Good morning, sir.
Thank you.
All right, Mr. Barrows, you're an attorney representing the property owner?
Yes, sir.
Okay. Let me hear from the city first. Again, this is a case that has been previously adjudicated guilty by another magistrate with an abatement date of September 15th and a fine set of $350. The first case is about a sewer drain. Shanna Sanders, please tell me what this is about.
Shanna Sanders, City of North Miami, Neighborhood Service Inspector. This case, just like the first one, is about for 2700 Northeast 7 for sewer lines, pipelines, damage that was done into the property through the pipes that needs to be repaired. A permit was submitted to the city. I received a phone call from the city about an explosion that happened. I myself, the building official at that time, as well as the fire department, went out, inspected the property. We observed what appeared to be an explosion throughout the unit. They were cited and informed that permits need to be obtained. At that time, they did apply for a permit. However, through the course of the past year, work has stopped. A lawyer became involved. I understand there was litigation between the condo and the unit owners. As of my last reinspection, permits have been applied for but has been expired, which is the next case. But I'll let the lawyer and the property owner explain what's going on, why is it taking so long with fixing the unit and with obtaining and securing the necessary permits and getting them renewed.
Okay, so this is the, I guess I would call it, for lack of a better term, the a companion case to case number 44, which was Unit 48. this is unit 47, correct?
Yes.
Okay. So it's a question of, pointing fingers. Everybody's pointing fingers at everybody else. So let's hear from the attorney representing the property owner that was found guilty. And let's hear from Mr.
Yes,
Barrett.
sir. Yeah, thank you, sir. Yeah, I heard your questions at the prior on the prior case, and I think maybe I can provide some clarity here. So first of all, Ms. McClure, she's in a very difficult position here. As a bit of history, she has a 99-year lease on Unit 47 of the Fairmont House. Last year, pipes, the common pipes that service her unit, at least her unit and the unit above her, Unit 48, started backing up, so the sewage would come back up, come into her unit, and it would come into Unit 48's unit. The Fairmont House had been investigated and determined that it was due to the failure of that common pipe in an area located underneath Ms. McClure's unit. And they decided that in order to repair it, they would trench through her flooring to get to that pipe rather than go from outside the unit. They asked, even though they are repairing common property, for whatever reason, they asked my client, present my client, she's not a lawyer, she's not sophisticated. They just asked her to sign this permit, and as a good neighbor, she signed it. But it was a permit to fix their property. She signed it on the condition, though, that they would give her a detailed list of exactly what they planned on doing out there and for how long. She wanted to know how long she was going to be out of her house and what they were going to do about fixing up the trenching the damages that were going to cause. They never did that. They refused to give her any kind of guarantees. So we asked that they stop the work. They did for a time, but now they're back at it. And Ms. McClure has called the police on them. The police have refused to trespass them with the idea that the association is entitled to go in and do the work that's necessary to protect common elements. You acknowledge that that's more likely the case. So we have a situation where the association is doing work on property. They're using my client's unit to do work on their common property, and my client's being assessed with the responsibility of maintaining permits for their work. And I think if there's any permit issue, it's purely falls on the association to obtain the necessary permits for this work.
Are you in the process?
Excuse
me. Are you in the process of litigating whose responsibility it is?
Yes.
And what's the status of that case?
We're stayed at this point.
Pending what?
We had to take further action. They're asking to arbitrate the matter.
Arbitrate or mediate?
Arbitrate.
Okay. So your position is that it's not your client's responsibility to maintain the pipes, but that in order for the association to get into the pipes, they have to go through your client's unit.
I don't think that they have to go through my client's unit. That's probably the easiest way for them to do it, but there's nothing that's preventing them from trenching from the side. That's done all the time to access utilities that aren't accessible straight down. You can access through the side. I presume that's more expensive for them to do that, and they've chosen the least expensive route, not to trench through my client's unit. But I can show you the condo docs, which clearly state responsibility for maintaining the plumbing system and the common elements is the association.
As I did with the other unit, I'm going to table this for my next meeting, and I would appreciate it if you would send over the pertinent condo documents. And by the way, I looked at the file. I saw no photos at all. So if there are any photos of the condition showing the area and where it is and what's being done about it, that would be helpful. So your client was found guilty. I guess she didn't show up at the meeting of August 6th. You understand that?
Yes, I understand that.
Okay. I'm not going to ratify the fine yet. I'm going to see ultimately who's responsible. And if the responsibility lies with your client, then I'm going to ratify those fines at that time. But I'd like both the city and the condo and the two property owners to provide me with either a memo, condo docs, exhibits with your respective positions by my next hearing. I read everything. I have done plenty of condo law litigation. I have sat on these kinds of disputes before, both as a city attorney and as also as a mediator, by the way, and a special magistrate. So I am very familiar with the issues, but I need the information to be able to make an informed decision. So I'm gonna, like the unit 48 previously, we're gonna table 47 as well, and also I would like the city to cite the condo association, because in most cases these pipes belong to the association, and anyone else that wants to come in, whether it's an insurance company or an adjuster or an engineer, will set aside, maybe 15-20 minutes if we have to, and we'll listen to all the facts and see who's to blame and find the responsible party. So let's not do it today. I'm not capable of giving you an answer today. It has to be done after all the testimony is in. So Mr. Barris, you can have a nice day. I'll see you next time.
Okay, thank you.
All right, Ms. Sanders, I need as much information as possible, including photos.
Okay.
Whatever you can get. Anyway, okay. Miss Jennifer and the husband, please allow the inspector to do whatever inspection and whatever photographs she needs to take, whatever she needs to do. Please allow her in. Talk to each other, and then we'll talk again in about a month or two. Can't hear you, but I hope that you understood what I just said.
Yes, thank you.
Okay, and in the meantime, let's hope that they finally fix it. Okay, next case.
Thank you, Magistrate. Next case is case number 20. Jose Luis Umbert, CEBPR 2024-00097. Inspector for this case is Ms. Shanna Sanders. And I do have an Andrea Cunningham joining us.
Yes.
Ms. Cunningham, are you the property owner?
I am not the property owner. I'm the permit expediter. In this link, the power of attorney she's assigned here. I'll ask her to raise her hand. That way she can be added. We have the power of attorney recorded in Miami-Dade County.
So Ms. Ana de Cardenas is the owner?
She's the power of attorney.
Okay, so Ms. de Cardenas, I'm gonna go ahead and promote you as a panelist as well.
Wait, let me make sure that I understand.
Yeah.
You're at this hearing, you have a power of attorney who was given to you by somebody else that has a power of attorney?
So I'm the permit expediter for this property. I have Miss Ana de Cardenas, who has the power of attorney. She's in charge of the property at the moment due to the owner is in Europe taking care of his mother. She's very ill. Miss Ana is in the meeting. We've been here since 9:30, but she's waiting to sign in.
All right.
He's already there.
I would feel more comfortable if Ana de Cardenas,
yes, sir,
who has the power of attorney, would testify, as opposed to you, who's the plan expediter. I may call you as a witness, but I want to hear from the person that has the power of attorney.
Yes, sir.
And she needs to be sworn.
Yeah, Mr. Cardenas, we need to see you. I can't see
How
you.
do I do that? Where do I? Oh, video.
Video.
Please help. Okay. No. How do I put the video on? Oh, start video. Start my video. Sorry, my first time.
Well, Mr. Cardenas, let's go ahead and sworn you in first. If you can please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say, I do.
I do.
Yeah.
Okay. Let me hear from the officer.
Shanna Sanders, Neighborhood Service Inspector. This is a new case for 2000 Northeast 131st Street, Unit 606, for building without a permit. I initially inspected this property July 3rd of 2024, whereas I received a call from the actual tenant at that time, who brought to my attention that the property owner converted the 1-bedroom apartment to a 2-bedroom. At the time I did the inspection, what I observed was a 2-bedroom apartment. I sent notices out to the property owner. A few months later, made contact with me, I think through his sister or someone, stating that they needed more time. They were trying to evict the tenant. They were debating whether there was a conversion at all. At that time, they did get into the unit after the tenant was evicted, confirmed that there was there was a conversion that was did, asked for me to again work with them. We gave them some more time. As of my last reinspection, I do see that they have submitted permit applications to the city for the conversion. However, they've been denied. I've been in contact I spoke to the gentleman one time, and I believe again his sister maybe twice. But again, they have submitted permit applications that have been denied for the conversion that was done inside the unit.
Is this a condo building?
Yes, it is.
And about how many units are there?
I could look really quick.
This is unit 606, correct?
Yeah, that is correct.
Okay. Well, I can probably tell you that, just guessing, the reason its property permit has been denied is because of land use issues. Apparently, this building was approved with X number of 1-bedrooms, probably X number of 2-bedrooms, and by converting that 1-bedroom unit into a 2-bedroom unit, not only did they apparently violated the condo docs, they also violated the CO and the land use permits. That's my guess, but let me hear from the property from Ana de Cardenas with the power of attorney. What happened here?
Could I possibly ask you to speak to Andrea? She's more technical than I am. Okay. And she's been helping me. Thank you.
Andrea, tell me why a one-unit condo owner in a condominium building is allowed to turn the 1 unit into a 2-unit. Tell me why is that allowed?
Magistrate,
she needs to be sworn in. She has not been sworn in yet.
Wait, time out. You need to be sworn.
Thank you. Do you solemnly swear or affirm the testimony you're about to give on this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say, I do.
I do.
Thank you.
Okay. What happened here?
Yes, Mr. Jose. So this is
please speak up.
Can you hear me?
Yes, louder.
So the reason the property has not been turned into a 2-bedroom is actually has been turned into a 1-bedroom with a den. We submitted plans, mechanical plans, making sure that the air conditioning space is adequate. We have also submitted the electrical plans with the modifications and the architectural set. That went for review. We just received a second cycle, which electrical has approved, flood has approved, zoning has approved. The only pending discipline we have is building. We had an issue because the building officer, Mr. Carlos Fernandez, is who's reviewing our project. He said his last comment was to please call him. He's only there on Mondays. So we just spoke to him on the 28th. He posted these comments on the portal. We start working on it. Basically, he wants to see the existing and the before of how the apartment was. Our consultants are working on that to submit and send it for review. And that's where we stand on. Everybody, other disciplines are okay with the layout of the apartment. We just kind of have to see if we can get some extra time so we can send these plans for review, get it approved by building, request our inspections, pass the inspections, do a code enforcement visit, and close the case.
The pictures that I saw show what looked like a bedroom, and it had a bed on it.
Yes. So I think that the owners, the tenants were going to have a baby, so they were trying to create an extra space. But according to the mechanical and air conditioning, it will be fine. It's just, that's what we're trying to do, the permitting to do this new layout.
Well, at some point, it was being used as a 2-bedroom. So what I'm going to do is I am going to give you time.
Thank you.
I'm gonna issue an adjudication, and I'm gonna give you time to legalize it, change it, do whatever the building official or the building department requires you to do, so that it is not a 2-bedroom unit, but rather a 1-bedroom with a den, a real den, not a den with a bed and. You know, I'm sure you know what I'm talking about. It should not be a sleeping area. It may have a couch with a TV so that people can, it's like an entertainment room and so on, but not a bedroom. But I'm gonna give you time to convince and to do whatever you need to do to restore it to a 1-bedroom. So based on the testimony of the city's code compliance officer, the photographs and the evidence presented showing that the violation exists and that proper notice has been given, I find in favor and enter an adjudication and set a compliance date of 60 days. That is December 3, 2025, 60 days for you to comply with the requirements of the city. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. All you got to do is just make it a den and not a bedroom.
Yes, sir.
Thank you. And you have until December the 3rd in order to do it.
Thank you.
Okay?
Thank you, everyone.
Thank you.
After December the 3rd, you're going to start getting fines.
Yes, sir.
Okay. Next case.
Sorry about that. Case number 43.
All right, we can take out Miss Ana de Cardenas. We don't need her.
She's
okay.
Already.
23?
No, 43.
43.
Miss Rita Gallagher, if you could please accept.
Okay, go ahead.
Ms. Rita, you're declining the invitation. Can you please accept the invitation? Okay. Then let's move on to case number 18.
18?
Oh wait, Ms. Rita, she's accepted.
All right.
My apologies.
Yeah, let's do that.
Ms. Rita, are you? I'm not sure what's going on. All right, so I'm sorry about that. Magistrate is we're going back to case number 43.
43.
Yes, she shows
Okay.
accepted it. Ms. Rita, if we can, I need to see you. If you could please unmute and no, we can't hear you.
Welcome, Miss Rita Gallagher.
We also have Mr.
Are you the property owner together with your husband? Or I see another name here, Stephen Gers.
We can't hear you, ma'am.
And I see an attorney, Kenneth Scher.
Morning. I'm here for Mike Manco Air. I don't see him on the screen though.
Which case is that, sir?
It was number, excuse me, number 43.
All right. And
who else is it that you need to? I'm sorry. I have Rita. I have Kenneth, and who else is part of 43?
There should be a Michael Mano or a Laura.
Michael Mano. Okay, let me allow him. Mr. Mano, I'm allowing you to be a panelist. If you can please accept it. Thank you very much. Ms. Rita, we can see you, but we cannot hear you. And Mr. Mano, we cannot see you nor hear you.
Mike, turn on your video and your audio.
There's a little button that looks like Larry King's microphone.
You're dating yourself.
Yeah. And who else? My number 43 says Stephen Gers.
Yes, same for me.
I believe from what I read that he's a joint owner.
Yes, I believe the wife is signing on. I spoke to her as well as the contractor yesterday. I believe, and once they get in, maybe they can confirm. I believe this was the case where I think the husband has passed away.
Okay.
But let me let them
Somebody's going to have to explain to me what a mini split is, because it sounds like
it's an
ice cream cone.
air condition. It's a small air condition unit.
Okay.
You've seen them.
It sounds like a banana split.
Yeah, it's a small AC unit.
They're small, highly efficient air conditioners that are good for rooms and small apartments.
Okay. All right. Let me see if everybody's on. Now, Ms. Gallagher, you're going to have to turn on your phone by clicking on the microphone.
Yeah, we can still not hear you. We see you, but we can't hear you, ma'am.
Counselor, can you see me and hear me?
Yes, Mr. Mano, we can see you and hear you.
Okay.
We cannot hear Miss Rita.
Well, I think you can deal with me. Stephen Gers.
Oh, wait. Let's keep some order here.
Okay.
Let's have the inspector explain to me what this is all about, why she cited the property owner. You know, the section of the code, I'm familiar with it. 532 is building without a permit. What are we doing? What is this about?
Yeah, understand.
There is no photo in the file. It'd be very helpful going forward if you have the ability to take a photograph of something. I mean, that to me, a mini split, it had no legal significance. So if there would have been a photo in the file, it would have been helpful.
Okay, Shanna Sanders, Neighborhood Service Department inspector. I will make sure to include photos of a mini split from this unit. It was with a short okay. Shanna Sanders, Neighborhood Service Inspector for 2700 Northeast 135 Street for Unit 9. This is cases for a building without permit or installation of an AC unit without first obtaining a permit. This violation was brought to my attention through a complaint. Long story short, a resident came in, gave me a list of several units in the in this condo complex that did permits and did work without first obtaining permits. I at that time gave courtesy notices, did not get responses from everyone, moved forward with opening up violations. At the time of opening the violation, of course, now responses come in. They stated that they would obtain the permit for which they applied for, I believe at that time. However, the permit was not obtained. I moved forward with filling it. I do believe at that time they went ahead and secured the permit. It has now come and gone a year later. The permit has expired. The mini split has been installed, and they still need to secure the permit.
Okay, so explain what the mini split is.
It's a small AC unit. It's the best way I could explain it. It's an air conditioned unit instead of being.
One second, Mr. Sherwood. Just let her answer. I'll ask you plenty of questions later.
It's a small AC unit.
Is it plugged in? Is it attached to plumbing? I mean, how does it?
I wouldn't say I can't really confirm as to say it was installed. If it's plugged in or not, I would let the building department in or the contractors explain how it's installed. From what I see from the outside, all I see is a unit that's attached to the wall. How it's installed internally, I'm not comfortable with saying.
Okay, so has the building official been asked, or has the building official determined that as a matter of code that it needs a permit for the owner to be able to install it?
It has been confirmed through the building department that a permit is required for installation of mini splits.
Okay, that's a determination made by the building official.
I would say the building department. I don't want to say the building official, but I have contacted the building department and have inquired, is a permit needed for a mini split, and I was directed yes.
Okay, all right, that's fair. All right, who wants to talk first, Mr. Mano or Mr. Schur?
I'll give you a little background. A mini split is a modern version of what we used to see as the window shakers, but it's a split system. You have one piece that's outside and one piece that's inside. So it's split, but they're more efficient and it's far less involved in a central air. Typically, they're used for a room or a small apartment. I'll let Mike Mano describe for you the process that he went through for permitting and what caused the delay.
Okay, I want to tell you up front so that everybody knows. I have no authority, no discretion to overrule the building official. So whether it's a good idea, whether it's a good idea or a bad idea, whether it makes sense or not, if the building department determines that a permit is necessary, you need a permit.
We're not disputing that it required a permit.
Okay, because I thought it was something like you plug into the wall and it's got some device that makes it cool the air. I've heard of those devices.
In about 2 or 3 years, it's going to be like a plug-in.
Okay.
It's gotten to be that simplified.
Mr. Mano, tell me what the permitting
He needs to be
situation-
sworn in. Mr. Michael Mano needs to be sworn in.
Yes, okay, Mr. Michael Mano, you need to be sworn in.
Thank you, sir. Do you solemnly swear or affirm the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Thank you.
Okay, so what is the problem with the permit?
Well,
it was applied for, it expired, it needed to be reinstated. Where are we?
Well, Counselor, first of all, I beg your indulgence. I'm a little nervous. I never had to defend myself in this fashion. This is at the Fairmont House. I've done several units in this building, all of them permitted. I don't know if you can see this.
What is it?
This is a receipt from the city of North Miami. I submitted paperwork 5/31/2024. I spoke to Paul Raymond, who's chief mechanical. By the grace of God, he found the original paperwork and looked it over and he approved it. The only other hurdle I had to jump through was, where's his card? I had to get a flood officer to sign off on because the building is right on Biscayne Bay, it's in a flood zone. So that I was a little dismayed to hear that you didn't get my picture, my evidence.
All right, so let's go forward. Whatever happened, happened. What is your evidence? What does it show?
It was a picture of the mini split.
Okay.
It was submitted after the fact. You had till September 15th.
There's a time deadline by which you have to submit, but
he'll explain to you why he was laid up for about a year. Mike,
okay.
Let him know what happened to you.
Not long after.
By the way, are you a contractor?
Yes, I'm the qualifier for Manco Air.
Okay.
Not long after submitting the paperwork, I contracted COVID, which knocked me out for I was to quarantine for about 10 days. Around November of 24, I started to lose feeling in my legs after walking a short distance. I went to a surgeon and he said I had a severe case of scoliosis and stenosis, if you know what that is.
I have done enough personal injury work to know the difference. I just don't.
All right,
I don't see the relevance of it. You were ill.
Well, I flew to Boston to have surgery because I was going to get up in a wheelchair.
Okay, I understand that you were very ill. I know what scoliosis is, and I know that people that have had COVID have had horrible experiences. I know all that. So you're telling me you could not follow up on the original permit application because you, as the qualifier for the air conditioning company, you could not do it.
I was not mobile.
He was immobilized for about a year.
Okay, so all right. I understand, and I empathize with you. I know a lot of people in your situation. So, how much time do you need to get your permits?
I spoke to Gary Beswick, who is the flood officer, this morning. He said, I always thought I could email any additional addendums to it. The city of North Miami says I can't do that. I have to bring it in. So my wife can take a vacation day and drive me there tomorrow morning. And that's the only.
Where are you at now?
South Pompano.
Okay.
I think my address is in the file.
Okay, so in any event, how much time do you need to finalize the after the fact or restore the permit? How much time?
I don't think 2 weeks is plenty. If I can get 30
Okay, I'll be happy to give you more than 2 weeks. I understand your situation. So you have basically you have to reinstall reinstate the permit for the unit for the mini split, and it's a matter of timing. Is 30 days okay, or do you need more time?
No, that's plenty.
We have Miss Shani Pressy would like to say something.
Okay, does anybody else wants to speak?
Miss Shani Pressy. Shani,
right.
we can see you or hear you.
Building official.
The application that he submitted back in 2024, that permit application is considered abandoned. So he would need to make sure when he come back in the office to submit a new application with all the necessary documents that is needed, because the application is considered abandoned. So the application is no longer here in the office.
Okay, so he needs to start the process all over again and reapply for a new building permit.
Correct.
And how much time does he need in order for him to file all the paperwork, for the city to process it, and then do a final inspection if necessary? How much time do you think he needs?
Oh, you asking for my opinion? It's up to you. It's up to you, Your Honor.
Yeah, I mean, but if in the normal course of events in the city, how long would it take him?
30 days, so 60 days. He can.
All right, I'm going to
get it completed.
I'm going to give him 60 days. If for whatever reason there's an emergency, or God forbid he gets sick again, or if nobody can do it, or if he needs more time, this is not a life safety issue.
Ms. Saunders, may I ask you a question?
Yeah, sure.
Why would Paul Raymond tell me that he would approve the original paperwork?
Well, I can only, you heard the building official. She is the head of that department.
I'm sorry.
So her testimony is that under the building code, the building permit that you received in May of 24 has expired. Why has it expired? Because I think that they're only good for a year. I believe that's what the building code says, right, Ms. Presley?
Can we reopen that permit application?
Can it be reopened, or do we need to file all over again? And
he needs to submit a new application. The reason being, being after it's no activity on the application, it's considered abandoned. And
it's considered abandoned because
it's past the 180 days.
Okay, that's what I was getting at. Mm-hmm. This is not something that people just say things to say things. There are code provisions, and the building code says that after 180 days, if you haven't done anything with a building permit, it's considered abandoned. Okay, now, is it a big deal to file a new building permit? I don't think so, especially for something this simple. So if you need 60 days, I'm happy to give you 60 days. Whether whether you have to pay for another permit or not, we're not talking about a lot of money, are we, Miss Building Official? What is the cost of a permit? A couple of $100?
The permit was never obtained. So the permit was never obtained. So after 3 months, really, it was no activities throughout the process. Once it was denied, yes.
So the application requires a fee with it?
Correct. So once he come in with the application, as he stated, the two reviewers will look at the application. As long as he have the required documentation, they will probably approve the permit, and then he can be able to issue it to him, and then he can call for a final inspection.
Right. Okay. But what's the cost?
Maybe like after the fact, maybe like $400, because it's double fee plus 100. Okay.
Can we waive the double fee?
It's up to the building official.
Well, that's why I'm asking you.
I'm the building officer, so it's up
Okay.
to the building official. I can't
Okay.
ask her about it, and give me a second. Let me make sure.
Well, you know, the gentleman was deathly ill in a Boston hospital, and I think that there is some discretion on the part of the building department as to whether the double fee applies or not. I think that there's some discretion on that.
Okay, give me one second. I'm finna find out right now.
It was so bad, in fact, that
Yeah.
he was on a roof and his foot gave out and he couldn't even get
Yeah.
off the roof.
Apparently what happened was that he filed an application, but he never followed up on the permit. I know.
Hello?
Yes.
Yes, the double fee will be waived.
Okay, so I saved you some money and I gave you some time. Now, Mr. Mano, if you can't do it, then somebody in your company is going to have to help you.
I can take care of it.
Okay, so if you won't have to pay the double fee. I'm going to give you 60 days, and then we see where we are. Okay, it's not a big deal. Let's not make a big deal out of something that's not a life safety issue. Okay, so what I'm going to do is I'm going to adjudicate the property owner guilty, and just so that the property owner doesn't freak out, I'm not imposing a penalty or a fine. Okay, Rita Gallagher.
Is there a necessity for an adjudication?
Yes, because I have no discretion. The code was violated. The fee, the permit was suspended, and so I have no discretion as to that. My only discretion is I don't have to impose a fine. I will not impose a fine, but there will be.
You can't withhold.
It will be an adjudication with no fine, no penalty, as long as see I have to keep the case open to ensure that the work is done properly. So based on the evidence presented and proper notice having been given, I find in favor of the city, enter an adjudication and set a compliance date of 60 days is December 3rd. Is that correct, Madam
Yes,
Clerk?
60
December
days.
3rd, 2025?
December. Yeah, December 3rd. Yes, sir.
Yeah, and in the event of non-compliance, there will be a daily fine of $150 until the violation is abated.
Did you set a fee? I'm sorry, I couldn't hear you.
$150 fine in the event that the violation is not abated by December 3, 2025. Now, you know, it's not the end of the world if, you know, you're a couple of days late. I'm sure that you're not going to be fined, but you know, just try to move as much as you can. If you should need an extension for whatever reason, I will consider a brief extension if you need more time. But we got to get this permit done because I have no authority to overrule the building official on the requirement for a permit for this particular contraption. Okay, I call it because I'm not familiar with it. I've never seen it. But anyway, good luck. And I hope you feel better, sir.
Thank you.
You know, as Bill Clinton used to say, I do feel your pain, and I really mean it sincerely. You know, I've seen a lot of horrible cases in my lifetime, and you know, you're sitting there and you're looking like you'd rather be somewhere else. I know. Okay, thank you, sir. Let's move on.
Magistrate, can we please have a 5-minute break? I need to use the restroom.
Yes, normally I do like to have some a recess, but I understand that the inspectors also want to finish so they can do their job. I usually do call for that. Let me call for a 15-minute recess.
Thank you.
15-minute recess. It's now approximately 12:05. 15 minutes, and I really need to finish this meeting by 2 o'clock. You think we'll be able to do it?
I have 10 more attendees waiting on the waiting, and we have 46 cases.
We have only heard 10?
No, we have 10 more attendees waiting to be heard their cases. Because
Okay,
usually
that's the
once
other-
that we're done with the attendees, the agenda will move on faster. But when we have an attendee, it's, you know, it takes a
Okay,
little bit longer.
I understand, and I'll try to move a little quicker, and let's make it a 10-minute recess instead.
10 minute.
Okay,
got it.
let's do a 10-minute recess, and then we'll continue and move along a little quicker. Okay?
Perfect.
Bye.
Thank you, Magistrate.
Recording stopped. Recording in progress.
Okay, we're back.
We're back.
You hear me?
Yes, I can.
Okay. We're ready for the next case.
Yes. Next case is case number 6. Case number 6, Benita Darouche, CERCV 2023-00365, found guilty by Magistrate Casu, must abate by July 18th, 2025. Fine set at $200 plus 100 cost assessment. The inspector for this case is Mr. Alex Bernardin.
The property owner present.
I just let.
Yes.
We can hear you. Oh, there we are.
Yeah.
Okay.
Benita Darouche.
Mm-hmm.
I am her husband.
Okay. All right.
My name
Let's
is Saeed.
swear you in.
Sure.
Yeah. I need to see your right hand, sir.
Okay, let me go up on the camera.
Who's Benita? The one with the yellow shirt?
Is my wife.
Okay.
My name is Saeed Darouche.
I don't know. So do you solemnly swear or affirm the testimony you're about to give in this proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Thank you.
Okay. I'll let the inspector briefly summarize the case. I've already reviewed the file and I've looked at the pictures. And this is a case where there have, from what I read, there have been repeated violations of recreational vehicles, including a boat, other vehicles over the years, and you've already been found guilty. So is that pretty much it, Inspector?
It is, sir.
Okay, because I need the city to confirm what I just said. Now, at this time, they're keeping a boat.
Oh no, currently there's an RV that's been there dated back from 2023 that's still at the property.
Okay, it's a motor home, according to your notes.
Yes, sir.
Okay, Benita, I'm not very sympathetic when people violate the law, and I'm less sympathetic when you violate an order from a special magistrate that told you clearly that in May of 25, May 7th, told you that you had to get rid of that motor home by July 18th. And here we are, in October, and you still have that motor home there. I don't think that there's anything you can tell me short of you got rid of it last night that is going to make me happy. But I'm going to give you a few minutes to tell me why I should not ratify the fine that was entered by the special magistrate back in May.
Your Honor, if I may.
Of course, I'm going to give you time.
So listen, we.
I'm sorry, you have not been sworn in either.
I'm ready.
Sir. Thank you. Do you solemnly swear or affirm the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
I do.
And then if you please, what's your name? And yeah, correct.
You're not the owner of the property, are you?
No, I'm not.
Okay, so I want to hear from the owner.
Well, the thing is that the reason I'm here is just in case Saeed has a problem, I was going to translate. And since you don't have translator, plus I don't think your translators speak Arabic, so that's the reason I'm here. I'm also his neighbor, and I'm helping him, fix this problem with the truck. So he, at a point, he has a letter, was asked to go in front of the board of adjustment to ask for a variance to have the RV there. So we focus on helping him on that. And now I am a member of the Board of Variance of the City of North Miami. So
okay, then, sir, that respectfully, you have a conflict of interest.
No, but he's not going because of the zoning. Because of the zoning of that particular area, that's not allowed.
Well, if you're a member of the zoning board and you're testifying in the property owner's favor, you have a conflict of interest. Nonetheless, I doubt seriously that the variance would be allowed for a motor home in a single family residential neighborhood.
Well, they do that all the time, sir, with all due respect, but...
Well, I haven't seen it too many times.
Well, I have. But the thing is that this is not a single family zoning. This is for they can put more than a single. They changed the zoning, and now they can put like townhouses up to 3. So because of that, it's not allowed the variance. But what I'm telling you, Said has tried to remove this big thing that was given to him, and we already started the engine, and we already secure a place where to store it. But he only needs like 30 more days, and he'll be out of there. Said is a handyman, and he has a lot of work, and it's been hard for him to remove the truck. But I've been helping him. I am retired. So we're trying to, he's going to comply, and I can assure you that he's my neighbor, and he helps everybody. But, as we said he's just, I told him this is since 1923. You should have fixed this long time ago. So let's do it.
I'm not persuaded. He's had plenty of time. This goes back to 2023. There have been multiple violations. Whether he could or he couldn't get a variance, this should have been resolved months ago. And so I am going to, based on the testimony of the city's compliance officer, the file that I've reviewed, the photographs, and all the evidence presented, showing that the property is still out of compliance, that there have been repeated violations, and the motorhome is still there, I find in favor of the city, ratify the fines accrued to date in the amount of $200 per day, and assess costs in favor of the city. The fines shall continue to run on a daily basis until there is compliance, and I authorize the city to enter the lien if they find it necessary. So, sir, I'm sorry, it's too late. There's a court order. The thing, in a half an hour, it shouldn't take months to do it. So I'm sorry, I have to do what I have to do. You have to respect a magistrate's order, and you of all people sitting in the planning board should be applauding what I just said. And
not the planning, sir.
Okay, okay. Next case.
Thank you, sir.
Case number 28, R&N Global Investments LLC.
You still have the prior case on the screen. Can you remove that? Okay. All right.
Here we go. Sorry, case number 28, R&M Global Investments LLC, CEBPR 2024-00058. Inspector for this case is Mr. Joseph DeSanchez. And we have Mr. Mike Elbum on the Zoom meeting. If you, Mr. Elbum, I can see you or hear you, sir.
I'm here.
Mike Elbum.
Yes, sir.
Okay. You're the owner of the property?
I am the permit expediter. I submit.
That's not good enough.
I submitted a power of attorney.
This morning.
He has?
Yes, we submitted to the city in the email.
In the morning. That was not accepted, sir. You had time to submit any
Most of the with all the respect, well, most of the cities that we represent, the clients, they don't need the power of attorney, so we didn't know what you guys are referring to that. But as we were with that, I submitted right away.
Sir, whether you did or not, you know, the property owner should be the one to appear.
He doesn't know how to talk to the court, Your Honor. He's not from here, and he's been tricked so much. And he's also on the hearing. He cannot be also talking, but he's here. He's reviewing it from his house.
Well, what does he speak? Hebrew?
No,
he speaks English. I spoke to him before.
Yeah,
English.
Yeah, he speaks English.
Okay. Well, I'd like him to tell me under oath that he gave you a power of attorney to speak on his behalf.
Absolutely. Eduardo, do you hear us? Do you see him plugged in or something? I don't know.
Is it Eduardo Uribe or?
Yeah, I think so, yeah.
Eduardo Castro. Okay. I am going to, there's a Mike album as well.
Right, because we joined together on the same link. He didn't know how to connect.
Okay. Can you please raise your hand? I'm trying to figure it out. Who's part of this case? I'm not understanding.
Eduardo, can you raise your hand?
Eduardo.
Okay, I'm trying to promote him as a panelist, but they're not accepting it. So.
Can you text him and get his approval that he is approving me to talk on his behalf? It will help.
No,
Hello.
All right, here we go.
Good afternoon. Hello, how are you doing?
What's your name, sir?
Eduardo Alberto Castro Hernandez.
Okay, I got them all. Eduardo Alberto Castro Fernandez. Hernandez, okay.
Yes,
you speak English?
Yes, sir.
Okay. Mr. Mike Elbaum here is telling us that you gave him a power of attorney to speak on your behalf?
That's correct, because he's my new and the new guy I hired, because the last one I have, and I go to the city to speak with Inspector De Sangre a couple of times. They proud me. I put money. They start to do it.
Okay,
but...
stop. You're going too far. I just asked you if, first of all, I'm going to put you under oath. And has he been sworn?
No, me also not yet.
No.
None of them.
So both of you raise your right hand.
Okay. Do you solemnly swear or affirm the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Okay. I don't need to go back in history. All I need to know is whether you, Mike Elbaum, and by the way, are you the owner of the property?
Yes, sir.
Castro.
I'm the owner.
Okay. What number are we, Madam Clerk?
28.
This is number 28, Magistrate.
Okay. And so the owner of the property is R&M Global Investments LLC. Who are they?
That's the LLC that Eduardo have as an entity to hold the house.
No. That's the previous owner of the home. And since I buy the home, never I don't know how to say, never refresh on the files or something about on my name. I don't know what have that name, to be honest.
Okay, Madam City Attorney, did we cite the wrong party?
Yes.
I'm checking now, Special Magistrate.
Unfortunately.
Inspector,
yeah,
sir, if you can please give us a minute.
Mr. Elbaum, just remain quiet for a moment, okay? I normally look at Sunbiz just to be sure, but I don't recall having done it here.
So the property is 1010 Northeast 143rd Street. I just checked property appraiser and is currently right now, so of today's day, under Eduardo Alberto Castro Hernandez. But this citation or case was previously cited to R&M Global Investments, LLC.
Which doesn't make sense. So how would the name change? It wouldn't. It makes sense how the name would change if there was a violation on the property because it was cited on 2024.
Right.
So that's what's getting me.
Okay, I'm looking at my notes, and according to Sunbiz, R&M Global Investments LLC is a corporation. Is a limited corporation with the name Eduardo Alberto Castro Hernandez. So I think we got the right guy.
It's the same owner.
It's the same owner. It's the same person, same entity.
Yeah, and then we have a Paola y Montaño.
Correct.
That is
my wife. That's but I never created a company. I never put the house under that name. Just to be clear, I don't know what I don't have the name.
It's still your company. You're still an entity of the company. So that's probably why.
Well, somebody's making signs, Mr. Elbaum. I don't know that you can weigh in on this. They're either the owner or they're not.
He's the owner of that company.
All right, you need to put on your mic.
Okay, sir. I'm looking at the property appraiser. Miami property appraiser shows Paula and Eduardo as the owners right now.
Okay, it doesn't matter what the property appraiser shows. That could be different from Tallahassee. And it could be different. What we really need to look at is the clerk of the court's property records. That would tell you who the owners are. And I want the inspector to tell me what, and you have your hand raised, I guess. No. How did you determine ownership?
At the time that I cited the property, I looked it up. It was Eduardo's name, but he owns that company that you know how you can look up the name of the company and the owners of the company.
Okay, but where did you look it up? In the property records?
It was on. Give me a second. Let me show you.
So, if I may, I have it open here. Back in May 22nd, 2023, it says previous owner R&M Global Investments LLC. Correct. So, at the time of the citation was given, the property owner was R&M Global Investment LLC. After this, it was changed to Mr. Eduardo Alberto Castro Hernandez and Paola N. Montano. But at the time of the citation, the property owner, like we said before, it was R&M Global Investments LLC.
Okay, so that's what we have to go on. So having clarified that, and guys, you can appeal, you can file a lawsuit, you can do whatever you want, but I've got to go with what the inspector tells me was the ownership when the violation was issued. If the property changed names after that, there are issues, okay, on both sides. So let's not get into the weeds, and let's just figure out how you're going to get the after the fact permit for the carport conversion. Okay, because even if they cited an old owner, they can go out there tomorrow and cite you again. So the problem is not who owns it. The problem is fixing the getting the permit for the carport conversion and the additions that were made to the property. And from what I recall, the pictures of the house look very nice. I may be mistaken, but
No, the house does look very nice, but they did do the conversion, and that's basically what it was, just to get an after the fact permit for the conversion that was done. They applied for a permit, but it was never issued, and it has never been reverted back, or in the conversion still stands.
okay, sir. So, Mr. Elbum, what are you going to do? How much time do you need? This has to be corrected.
So what happened is that I'll keep the story short because I know your time is short, Your Honor. We went with new plans to the city yesterday, but we got it already before. And what happened is that the city told us it has to go to Miami-Dade County for a first review before it goes to the city itself. That process takes about 3 months just by Miami-Dade County. So I only asked.
Why do you have to go through Miami-Dade County for flood issues or?
Well, the new laws in Miami that every permit that you do for new construction or even after the fact for additions or anything like that goes to Miami-Dade to review.
And who told you that?
The city.
Inspector, is that your understanding?
Is there somebody from the building department that that's on here that can clarify that?
Hello, sir. Hello.
Yes.
Yes. So when you add in square footage to a property, yes, you will have to go to Miami-Dade County.
Is there any problem going to Miami-Dade County? How long does that process work, and what happens after they get approvals there?
So it depends on if your plans is in compliance, you should have no problem with Miami-Dade County. If your plans is not within the compliance, you will probably have comments that you have to make corrections with. I'm not quite sure that's his thing. I'm not quite sure why he's having a problem with Miami-Dade County. I haven't looked it up. But usually if they in the requirements, they should have no 30 days. It's a full review for the county. I say no more than 30 days or less.
No, I apologize. I did this process to several of my clients. None of them ended less than 90 days in the county before it's back to the city, and then the city give back reviews on that. So we in total, this is a long process, more than 4 months.
Which I was gonna say, Magistrate, it's been over a year. We're about to go to 2 years right now.
Are any of these,
there's been plenty of time.
any of these conversions, additions, any of it was either electrical, plumbing, structural, what?
Yes, it's all involved.
Okay. Have you done that, Mr. Inspector, did you see anything that stood out to you as being unsafe or hazardous?
There's a split. I believe there's a splitter on the pictures that was added. You could see the square footage and how the house was before and how it is now. I'm not allowed inside of the property, but the permit that they applied for last year said it was 2 bedrooms and 2 new bathrooms. So that's already that's plumbing, and I'm pretty sure there's gonna need that splitter unit is gonna have to have electrical run.
And has the work been done already?
Yeah, it's been done. That's the problem. They're getting an after fact permit because it's been done. I don't know if you had a chance to look through the pictures. It's been done. It's just
yes, Mr. Elbaum.
So the thing was that he took a GC over a year ago. The GC tricked him with the money. He took the money, told him that he would provide permits. He went and just submit a stupid permit in the city, took a number, and he told him, "Oh, that's your permit." So he was false by a GC. And now we are stepping in to correct everything past.
Which is understandable. But they did the work before they got that GC.
Yeah. You don't do a major construction job without a permit, and certainly you need plans. You
100%.
just can't go out there and do whatever you want. You need plans, and you need those approved by the city. Look, I'm going to give you 60 days. All right. If you have a problem with the county, and it's legitimate, or if you have a problem with the city, then, come back and tell me, ask for an extension. But as of right now, I think 60 days should be more than enough, especially if you're experienced, you're an expediter, you know how to do things, you know how to go to Miami-Dade County. And it's a single family, as I understand it, it's a single family home. It's not like you're talking about a multifamily property. So based on the unrebutted testimony of the city's code compliance officer and the photographs and evidence presented, depicting that the cited violation still exists. Proper notice has been given. I find in favor of the city. Enter adjudication and set a compliance date of 60 days. That's December 3, 2025. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. So you got 60 days. After that, you start accruing fines. If you have an emergency, if you have something that really is, you know, out of the ordinary, either with the city or the county, you talk to the inspector, and if you can't agree, bring it back in front of me, and I may want to modify it. But right now, as of 60 days, if you don't have the permits, you're going to be fined $350 a day. And that's all. Let's move on.
Thank you so much, Your Honor.
Mm-hmm.
Miss Almantos decline. Okay. I don't know why. Mark Kinley.
What number?
I'm trying to. The thing is that they keep. Okay, here we go. So we are on number 18.
Okay.
Thank you.
Hector M. Pose Gallosa.
Yeah.
Ana A. Alvarado.
I have
Alvarado.
Almantas. I can not see you nor hear you. We need to see you. We need to hear you. We need to know what's.
Hello.
Hi. What's your relationship to the property? Are you an owner?
My baby mama lives there. You know, we separated, but my child still lives there, and that RV was mine. I already moved everything from the property. That's why I'm trying to, you know, be here to represent the, you know, the place where my kid and my ex lives.
Are you at the property right now?
I'm not at the property right now. I was all morning, but I had to go to work. I got all the pictures and everything, and if it's necessary, I could be there in 20 minutes.
Well, here's what we're gonna do. First of all, you need to be under oath.
Yeah. So if you can please raise your right hand. Raise your right hand. Right hand.
Give me a second. I think I need a charger already because my phone got 5%. I was all day. Let me just run to another car where I have a charger. Give me 1 minute.
Okay, in the meantime, I'm gonna go ahead and read the case. Magistrate, case number 18, Hector M. Pose Gallosa, Anaya A. Alvarado, CERCV 2024-00019. The officer for this case is Inspector Alex Bernardin. Mr. Bernardin, are you? Yes, there you are. Are you ready, Mr. Karkauskas?
Yes, I'm ready.
Okay.
See your right hand, please. Thank you. Do you solemnly swear or affirm the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
Yes, I do.
Thank you.
Okay, we know what this is about. You said you were the owner of the RV, right?
Yes.
And your family lives at the property in question?
Yes.
You also own a boat?
Yes, that's what I want to explain, you know. That the boat, that's why there's like a misunderstanding from this one, as much as I see. Because like at first it was about a boat. The boat was moved long time ago, and then we just received this one about a RV. So RV was moved before 15th, and now it's clean and nice. You know, everything clean and nice. There's no violations anymore. So maybe I can, I don't know, can I add pictures here? But
Inspector Bernardis. Okay. You went out there and you saw an RV or a?
Yeah, when I went out there, I witnessed an RV parked out front on the in the driveway.
When did you go out there?
I believe it was
September 8th.
Okay.
On September.
I have photos. If I have it here, I can share it right
Yeah,
now.
I think I saw the photo. When was the last time you were there?
When I did the final reinspection, I believe September 17th, I believe.
September 15th is the final reinspection.
Okay. So
there's a picture of it today.
Right.
I can stop by following the case and do a reinspection.
Okay, look, the inspector is going to go out there. If everything's okay, we'll dismiss the violation. If it's not okay, it's coming back to me, and I'm gonna levy a heavy fine. And please don't play games with the city. Take it away for a week, then bring it back for the weekend, and so on and so forth. The next time I'm gonna be harsh. Okay, so keep the RVs and the boats and all these other things away from the property until if you get a variance from the city, which you obviously don't have. So I'm going to table this case and wait for you to give the inspector the photos, and he's going to go by there and take a look, and then we'll see where we go from there. Okay?
Understood.
Goodbye and thank you.
Thank you, Magistrate.
Thank you very much.
You're welcome. Drive carefully.
Always.
Give me a minute.
Next case.
Sorry, Magistrate. Case number 15, Fritz Munfisten and Jocelyn, CEBPR 2023-00834. It was found guilty by Magistrate Smith. Must abate by May 16, 2025. Fine set at $500 plus $100 cost assessment. The inspector for this case is Mr. Jonathan Lemestre. And then Miss Jocelyn, if you can please accept the invitation. Thank you very much.
Okay.
Miss Jocelyn, we need to see you, and we need to hear you as well. You can please enable your camera and the microphone.
Well, and I've been here since 9 a.m. Yeah, I know. I understand.
Well, we don't start till 9:30.
Miss Jocelyn, can we please? We cannot see you. We can hear you. We cannot see you.
I'm here.
Okay.
Yeah, but we don't see you.
Yeah, somebody tried to help me.
Okay, understood.
Okay, now.
There we are.
Mm-hmm.
Good morning. Can you please raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you're about to give on this proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Thank you.
All right.
Mr. Jonathan Lemestre.
Inspector Lemestre, first of all, I didn't see my order in the file. So going forward, please, when there's an adjudication and an order and a ratification, it's necessary to have an order in the file so I can review it, make sure that it's consistent with the facts So trust me, I didn't see it. I went through it 3 times. Anyway, we have a finding that I made. There's a fence was put up without a permit. I found the property owner guilty, and I said, get the permit for the fence by May 16th. And I set a $500 fine because I thought that it was necessary, and it was a what I would consider a very important issue, the fence. So please, ma'am, Jocelyn, tell me why I should not ratify the fines and make you pay the fines because you failed to comply by May 16th, which was plenty of time.
Yes, I understand that, Your Honor. And the thing is, right now, I have the permit. I did not receive your notice. That's the problem.
Where's the permit?
I have it right here.
Mr. Inspector, have you seen the permit?
That is not.
No, sir. As of the final reinspection, which was on September 14th, I didn't see any application or a permit obtained. But let me check our system to see if she did obtain it.
Okay. What's the date on that permit, Jocelyn?
That's not a permit. I have Ms. Chani Pressy that she would like to speak from the building department.
Who wants to speak?
From the building department, Officer Pressy, Chani Pressy.
Okay, what is it? A process number?
Okay, I'm trying to make sure we're talking about 1200 Northwest 125th Street.
Yes.
Yes.
Okay, so the application she came in to submit for the application on the 23rd of this month is in process now. So she have not obtained the permit yet. So it's in review.
It's right here in my hand.
That's just not a permit, ma'am.
That's an application. That's you were asking the city to give you a permit. That is not the permit. It has to be reviewed.
Okay, I didn't know that.
It has to be reviewed.
Wow.
Madam building official, do you see anything?
I'm building officer right now. Since she just applied for the permit, it's with zoning right now. So zoning and building need to review the application. Once they both reviewers look at the application, they're either going to approve it or deny it based on her submittal, and then we'll notify her whether her permit is approved or denied. So may take up to 30 business days or less, it depending on, but she just submitted it.
We're gonna table it for 30 days until November 5th.
Okay, but to me, when I see the permit number, I thought I was okay.
No, that's only a number. That's only a process number. That's not the permit. Does it say permit on it? Does it say permit on it?
Yeah, it's a permit number, BFPE.
No, it's a process number. You still need to wait. Ma'am, you need to talk to the building department about what you just showed us and see where it, wait for them to approve it.
Okay,
and if they don't approve it, if they don't approve it, you need to change it. Okay, you need to be in touch with the building department.
Which is
I'm giving you 30 days to finish the work. Okay, to get your permit. After that period of time, I'm going to ratify the fines that I imposed months ago.
Oh my God.
I don't want to put any more burden on you, ma'am, but you've got to
understand.
This is going to be priority number 1 for you between now and 30 days from now.
No problem.
Okay,
no problem.
Table it for 30 days.
Okay. So let me ask you a question. Do they go to write me a letter in 30 days, or I have to go?
You have to take it upon yourself to do whatever they want you to do. It's not up, they're not gonna call you and tell you everything. You have to take the initiative. Okay, you have to go to the building official at least once a week to make sure that things are going along okay. Go pay them a visit once a week for the next 30 days.
Okay, no problem. Thank you so much.
All right. Bye.
Okay, bye. Oh my God, please help me.
I'm sorry, ma'am. Go ahead, Madam Clerk.
Case number 14, Mr. Gerald Wilson, I'm trying to send you an invitation to promote you as a panelist. If you can please accept it, sir. Gerald Wilson. You keep declining the invitation. You're supposed to accept it. Okay, here we go. So case number 14, Francis E.V., CEODS 2025000072. The inspector for this case is Ms. Shanna Sanders. And Mr. Gerald, we need to be able to see you and hear you. If you can please enable your camera and your microphone.
Mr. Wilson, we can't see you or hear you.
None of it. I believe I have staff outside trying to help him out because he's outside.
Okay, I guess the inspector may know, but the property is jointly held by Frances V. with apparently her husband, Gerald Wilson, whose name doesn't appear, but he's on the title, so he doesn't need a power of attorney. He's one of the owners.
Yes.
Mr. Gerald, we cannot hear you or see you yet, sir.
He's at the window. They're trying to do something to his phone.
Hi, Magori.
Hi. Okay, here we go.
There we go.
Hello?
Hi, Mr.
All right,
Wilson.
we're not talking to Gregory Regis. We're talking to Gerald Wilson, right?
Yeah.
Okay.
Yeah, we're Gerald. Mr. Wilson, if you can please raise your right hand. Thank you. Do you solemnly swear or affirm the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say, I do.
I do.
Thank you.
Mr. Wilson, are you one of the owners of the property?
Yes.
Are you married to Frances V?
No, that's my mom.
Oh, so you own it in the way the title is written makes it seem like it's your wife.
Yeah.
Because JTRS means joint tenant. Okay, I get it. Anyway,
Okay, thank you.
I saw the picture, sir.
Yeah.
And it looks like a junkyard.
Okay, go ahead.
Looks, your house, whatever you own, is it a house? Is it a house or a business?
A house.
Okay. I saw junk all over the place. The pictures speak for themselves.
I've been working on it. I'm almost done. But in the last few days, the rain didn't let me finish it, and my dad got sick. The doctor says he's just beginning to have cancer in the stomach. So I had to take him to the hospital a few times for emergency, and then the rain didn't let me stop. But I just need about probably 2 weeks to finish.
Okay, Ms. Sanders, I saw the condition of the property. I would definitely cite this property owner.
Miss Sanders knows I'm been working on it because she passed by and she told me that I have put a lot of effort on it.
Okay.
No.
Right now, sir,
don't get that on record. I did not say that. Shanna Sanders, code enforcement officer, No, this case is for, as you already stated, items, miscellaneous items being stored outside. I didn't say a lot was done.
You didn't say what?
I did not say that a lot was done. When I re-inspected the property, he was out there doing some work. He asked for more time. As I told him, this has been open since January. I could not grant more time at all. The pile was very, 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 quite the contrary of what he's saying. It was a very small pile that was out for bulk pickup in comparison to what is located at the property in the. It's a lot more needs to be done.
I can finish it.
Okay, wait. You just can't talk whenever you want to. You got to wait your turn. Okay. First of all, the inspector is right. This has been going on since when? January of this year?
And I would say I originally cited him in January, but this has been going on since last September, actually.
Yeah, January 22nd is the citation. And yes. you can, sir, you can always, and I'm sorry about your father. You know, we all have tragedies in our families. We all do. But we're done with excuses here. I mean, nobody wants to live with neighbors like you. Okay?
I know.
So I'm going to give you 10 days.
Okay.
To remove everything. Okay.
Yes.
And if you have not removed everything to the satisfaction of the inspector, then I want the case will come back to me at my next hearing, and I will impose a $500 a day fine for failing to remove
the items.
Okay, this is not acceptable. Okay, so I don't need to say more.
Okay, thank you for the 10
days to remove it, or else it's coming back to me at my next meeting, and I'm going to impose fines after the 10-day period if you still have not removed the property.
Everything you say. Yeah.
Okay. Whatever you have to, you have to pay. You have to pay somebody to do it. You got to do it. All right.
Okay. All right.
All right.
Thank you.
We don't want junkyards in residential areas. All right. Let's move on.
I'm sorry, Magistrate, since this was tabled.
I'm sorry?
Was it tabled, the case?
Yes. It's actually no. No. I'm glad you asked.
Okay.
No, it's not tabled. Based on the testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 10 days from today. 10 days from today. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
All right.
Have a good afternoon.
Bye. Thank you, sir.
Let's go.
Okay, Ms. McKinley, I've been trying to send you promote you as a panelist. If you can please accept my invitation. Thank you. This is cases number 31 and 32, Magistrate.
31 and 32?
Yes, case number 31, Raymond Bastian, CEFLR 2023-00445. And case 32 is Raymond Bastian, CSCU 2023-00856. Inspector for this case is Mr. Jonathan Lemestre. Mr. McKinley, if you could please say aloud what relationship you have to the property.
Good afternoon. I am a commercial truck driver. I would like to ask for 10 minutes to pull over so I could proceed.
Okay, so I'm gonna call another case in the meantime, sir.
Thank you.
My pleasure. Sorry about that. Okay, I'm gonna go ahead and Kira Peralta. I am about to. Ms. Peralta. This is case number 45 and 46. YMP Center Court LLC CEBPR 2024-00100 found guilty by Magistrate Kasu. Must obey by September 15, 2025. Fine set of $500 plus 100 cost assessment. Case number 46, YMP Center Court LLC, MHVIO 2024-00075, found guilty by Magistrate Kasu, must obey by September 15. Fine set at $450 plus 100 cost assessment. Inspector for both cases is Ms. Shanna Sanders.
All right, is there anyone here on behalf of the owner?
Yeah, Ms. Kira, we cannot see you.
Hi, good
Okay.
morning.
Saw you briefly, but then you disappeared.
Yeah, this is, I'm going to be transparent. I'm the legal assistant for YMP Real Estate Management. This is my first hearing, but I do have some information regarding our any updates. We've been in contact with.
Wait. I think you jumped the gun a little bit. First of all, you have to be sworn in.
Oh, okay.
By the clerk. Is that your right title, or is it? I think we lost her.
I'm here. Sorry.
Oh, Cindy, what is the title that what should I be calling you?
So I am the executive assistant, but currently I am the clerk. So
okay, but you are the executive assistant to the director. I just wanted to note that for the record.
Thank you. I appreciate that.
All right. Anyway, have you been sworn, ma'am?
No, I have not.
Ms. Peralta, can you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in this proceeding shall be the truth, the whole truth, but nothing but the truth? So help you God. Please say I do.
I do.
Thank you.
Okay, the inspector, you don't need to say much. I've reviewed the file.
Okay.
Okay, I've looked at everything, and I've determined that that there's no compliance, and there was no abatement, and there's a guilty finding on August the 6th by Magistrate Kasu. So I'm going to give the property owner a couple of minutes to tell me why I should not ratify these fines. Go ahead, Ms. Peralta.
Good morning. Yes, so my name is Kira Peralta. I'm the legal assistant. We have been in contact regarding the compliance with, let me pull up the email, with Kenneth Wenning from the city of North Miami. So we have been making strides to comply, but right now we're just requesting more time, if possible.
All right, I can't give you that. The fines will begin retroactive to September 15th of 2025, based on the testimony of the compliance officer, the code officer, and my review of the file, photographs, and other evidence. Property has been out of compliance since September 15th. And so I find in favor of the city, ratify the fines accrued to date in the amount of $500. Fines shall continue to run on a daily basis until there is compliance, and I authorize the entry of a lien. The order is exactly the same with regards to 45 and 46, same property, different violations, but essentially it's just a terrible situation existing as depicted in the pictures. So that's my ruling, and the property owner should be guided accordingly. A lien probably will be filed, and and it will have to be paid off. So anyway, thank you for appearing, but there's nothing I can do about this.
And approximately when would the lien be filed?
The lien probably, it's up to the city attorney. They do the filing, or the finance department. I don't know when.
It's the finance department. I would say maximum we deliver them, I don't know, 2 weeks from now. So keep that in mind.
Okay, so you don't want a lien to be put on your property because it's going to create all kinds of problems. You may have to pay a few $1,000s, but you know, that's the position you put yourself, so not you, but the owner of the property put itself in. All right, next case.
Yes.
There's for both of them? I'm sorry.
Yeah, that is been ratified for both of them, Ms. Sanders.
Yeah, both cases.
Mr. McKinley, are you ready now, sir? McKinley Guerrier.
Yeah,
there you are.
Let's move along, please.
We can't hear you. If you're still driving, I'm gonna have to call the next case.
Go ahead. Still not ready.
You're still not ready? Got it.
All right.
Mr. Eduardo Uribe, if you can please accept my invitation, sir. Eduardo Uribe. I'm not sure what case number is he. That's why I've been asking and he wasn't. Mr. Uribe, we need to see you and hear you, sir. We need to find out what case that you're here for today.
Unmute.
There you go. Mr. Uribe, what case are you here, or cases that you're here for today?
Well, I'm not sure that my case is to be taken care of today. Can you hear me?
Yes, we can. What is the property address, please?
The property address is 11930 Northeast 19 Drive. Somehow
let us look up the property
Give
first.
me 1 second, please.
Cynthia, Ms. Alvarez, I spoke with them yesterday. This is the property owners that we spoke to. You translated for 11930 and 11960 Northeast.
That's the one that went over for last month?
Yes,
So
we heard them at September. Yeah, I told him the abatement date was today, but not for the hearing.
Yeah, Mr. Eduardo, you're at the wrong hearing. You guys were supposed to show up last month. Okay.
Oh, last month. But the thing is that we didn't get the mail because they had the wrong address.
Yeah, sir, this is the magistrate hearing for October 1st. If you have any questions, you were more than happy to help you out. But right now we're on the October 1st.
Yeah, I had nothing to do with that case, sir. That was a month ago, and I was not serving at that time.
Correct.
So you'll have to deal with it separately.
Have a good day. All right, moving along. Mr. Gene Cherry, if you can please accept my invitation. Gene Cherry. Mr. Gene Cherry. Nothing. I have an unlicensed room. I'm not sure who that is. If you can please accept the invitation. Unlicensed room. And if you don't accept it, then we'll move along and then we'll start from case number 1. Okay, unlicensed room. We need to hear you, see you, and we need to change the name of the name on your Zoom. Can you please enable your camera so we can see you? Okay. right, they left. So, Mr. McKinley, are you, sir, ready? Or if not, we're gonna have to move along because we cannot be coming back over and over. McKinley, are you still driving, sir?
Yes, I am. If you could give me just about 5 minutes, I'll be able to pull
Okay,
over.
we can't, sir, we can't wait forever.
Mhm.
This meeting has to end at 2 o'clock, so if you don't stop within the next 5 minutes, we're done. We're gonna hear your case.
Yes, Your Honor. I will stop in the next 5 minutes.
Okay, all right.
Anyways, so Magistrate, let's go start by case number 1 in the meantime.
Okay. You can remove Mr. Guerrero from the screen. We don't need to.
Got it.
Okay. Okay.
So case number 1, Aquastrada Condo Association, CEVPR 2025 00237. Would you like me to read all the cases? Because it's the same.
Yeah,
owner.
let's hear them. Let's hear them all. Are they here?
No, there's no one
okay,
here.
so let's get rid of the first, I guess, 4 cases.
Yes. So case number 1, I already read it. Case number 2, Aquastrada Condo Association, CEFAW 2023 00111, found guilty by Magistrate Smith, must abate by May 16th, 2025. Fine set up. Who's talking now?
Could have gone better.
Okay. Hello, sir.
Cut him off.
I'm on it. Sorry about that. I forgot. Case number 2, May 16, 2025, fine set at $350 plus 100 cost assessment. Case number 3, Aquastrada Condo Association, COCMHS 2023 00695. And case number 4, Aquastrada Condo Association, CEPOF 2023 00005. The inspector for case number 1 is Jonathan Lemestry. For case 2, 3, and 4, sir, you have to wait. 2, 3, and 4 is Miss Shanna Sanders.
Okay, who's the gentleman
I have no idea. That's the person that I was inviting before, and they were declining my invitation. So he has to wait for his turn.
Unless he has something to do with these first 4 cases.
No, he has nothing to do with it.
Mute him.
Yep, done.
Okay, the first case it deals with dumpster enclosure. I already saw the picture, Mr. Inspector Lamastre. There's really nothing more to say. They have some kind of a dumpster in there, but the enclosure is a separate issue. They did it without a permit, and it looks terrible.
Yes, sir. No permit. I conducted my final reinspection on September 14th, and they failed to obtain an after-the-fact building permit for the dumpster enclosure.
And you've been properly, you noticed the association, and you got service, and you did an inspection, and it's still in the same condition.
Correct. Proper notice was given. I posted the notice of violation at the property and also mailed certified letter to the property owner, to the condo association.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance day of 30 days. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. Next case is Shanna Sanders.
He's been found guilty, so that one is either you want.
Okay. So anybody needs to say anything on behalf of the city?
Ms. Sanders.
Shanna Sanders, Neighborhood Service Inspector. As of my reinspection, compliance has not been met.
Okay, so the dirt and the mildew and the stained cement wall are still there as per the photograph.
Well, as per the photograph, they have repainted the building. However, along with the magistrate required them, as well as the city required them to obtain a permit. All commercial buildings are required to obtain a painting permit, for which they failed to do. They only complied with half of the violation, for which they are aware of.
Okay, they're not in full compliance then. So based on the unrebutted testimony of the city's code enforcement officer, the photographs and other evidence presented showing that the property has been out of compliance since May 16, 2025, the abatement date, I find in favor of the city and hereby ratify the fines accrued to date in the amount of $350 and assess costs in favor of the city. The fines shall continue to run on a daily basis until there is compliance.
Case number 3.
Number 3, Shanna Sanders, City of North Miami Neighborhood Service Inspector. As of my last reinspection, compliance has not been met. They have made minor repairs to the building. However, as instructed, they are required to obtain a permit, seeing that it is a commercial property. The city again required them to obtain a permit, which they have failed to do.
Right, and this is pursuant to an annual housing inspection. And there are pictures of cracks throughout the building, right?
That is correct.
Including stairway railings?
Yes.
Okay, so this has not been previously adjudicated. So based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city enter an adjudication instead of compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. When I say 30 days, does that mean my November 5th hearing?
That's November 5th, which is with Magistrate Casso.
Okay.
You're 60 days. But 30 days it'll be for the November one.
Okay. I'd like the 4 of them to stay together, so whatever I said.
30 days, you said you did 30 days before.
I said 30 days?
Mhm.
Okay, so that means that they have to comply by?
November 5th, 2025.
Okay, all right, so that will come back to me?
On December.
On December 3rd?
Yes.
Okay, all right. Last one is the gate. Did we deal with that or no?
Case number 4.
Shanna Sanders, Neighborhood Service Inspector. This is a new case for the pool that's surrounding the gate. Our city ordinance requires that any gate surrounding the pool needs to be self-closing and automatically closed, which this one does not. I initially inspected the property on February 23rd, 2023, while doing an annual housing inspection. I observed again that this gate was not self-closing. I've had several conversations with property management as well as the director, as the property management, as well as the president of the condo association, who, stated they were going through financial difficulties. They're going to get things done. As of my last inspection, the gate still remains non-self-closing, and they are making, minor, slow repairs to the building. I am showing property. My administrative staff, I believe, on the 8th of September. I'm showing that I posted the property myself for the notice to appear on the same day, September 8th, 2025.
Okay, is there water on the pool?
There is, I believe, no, I'm sorry. There is no water in the pool. The pool is damaged. I had to think for a moment. The entire pool is in need of repairs. They do have a notice around the pool stating that it's closed. There's cracks around it, around the deck and everything. The entire, that entire area is it's like a construction site.
They called you.
All right, that is not a good situation to have a pool in that condition. It usually, when it rains, you start getting mosquitoes. You can also have a child fall in. It's a life safety issue. It's getting real close here to issuing a a red tag, but that's not my call. But based on all of these conditions, if they don't move quickly to fix it, this sounds to me like an unsafe structure. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
$500, correct?
500.
Thank you. Okay, let's try
Let's
this one more
see if we
time.
can see Mackenzie again, because I, unfortunately, as I announced earlier, I've got about 30 minutes left before I have to leave. So why don't you...
Mark Kenley Guerrier?
And any cases that you need to adjudicate like right away, I'll take those.
The
But
ratified?
anything that can wait till the next meeting, I would appreciate it. I have a meeting that I can't, I didn't anticipate that we would have 46 cases, some of which were a little difficult and controversial, but let's see if
So
we
they're
can.
not answering as of yet. I'm gonna go ahead and
The unlicensed room was? Because they're still here. You know what?
there. So Mark Kenley Guerrier.
Yes. Yes.
All right, we're gonna hear you now or never. So
yes, Your Honor.
Okay.
I can't see you, and I still don't know what's his relationship to the property.
Can you hear me?
I can hear you. I cannot see you.
Yeah, we need to see you.
Said the host has disabled my camera.
Oh. Go ahead and start the video. My apologies. This is case 31 and 32. Sir, what's your relationship to the owner or the property?
I am the member of the LLC that is being cited, being fined. I would like to.
Is this?
Yeah, I am.
I'm sorry. Quick question. Is this for property address 1260 Northwest 135th Street?
Correct.
Okay. So this is case
30
number
30
31 and 32, sir.
Okay, there is no LLC here.
Exactly.
Oh, you mean the company MG Transportation
NEMT LLC.
Yes, honorable.
Are you involved with a transportation company?
Yes, I'm a member of that company, Your Honor.
Okay, so you're a member of the LLC that operates the MG Transportation NEMT LLC. You're part of them.
Yes, Your Honor. I'm the sole proprietary.
Okay, you don't have a BTR, you don't have a certificate of use. You've got to have it, or you can't operate. What's your answer?
Your Honor,
if I may, he needs to be. If you could please raise your right hand. Thank you. Do you solemnly swear or affirm the testimony you are about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say, I do.
I do.
Thank you.
Let's note for the record that the owner of the property, which is the subject of this violation, is not present. And this individual, his testimony may or may not be relevant or may not be accepted, but the owner is ultimately responsible for the violation. So, Mark Hensley, if you will have something to tell me about the BTR and the certificate of use, are you in the process of getting them? Are you having trouble? What's going on?
Your Honor, this is what's going on. First of all, I would like to say my company originally was classified as a local passenger transportation business. It has since been converted into a commercial trucking business. My company now falls under the jurisdiction of the Federal Motor and Safety Administration, which is the U.S. Department of Transportation, DOT. and the state of Florida, which regulate licensing, safety, and operation. The city of North Miami certificate of use requirement is a duplicative and unnecessary as applied to interstate commercial trucking operation. So my business address in North Miami is functioning solely as an administrative office, not as a passenger transport hub or vehicle yard. For this reason, I respectfully assert that the city certificate of use requirement not be applied and to my current federal regulation operation.
Sir, you have something going on at 1260 Northwest 135th Street, right? Whatever you call it, there's some business going on there, right?
Yes, Your Honor, but under federal administration, which is DOT.
I don't really abide by federal administration orders. I abide by the city code that requires any business to have a business tax receipt and a certificate of use. Whether you have authority under the Transportation Administration or the state is of no concern to me. The question is, are you in business and do you have the license to engage in business in North Miami? That's really a very simple question to ask, and I need an answer.
I am currently active on Sundays, Your Honor.
What is the problem with getting a business license?
I was under the impression that being in commercial interstate transportation, that I was under the impression that it didn't apply to me. It wasn't required for me to have a certificate of use. That's why one was never filed.
You may be in interstate commerce, in a transportation business, that you can probably do business in all 50 states. But that doesn't mean that if you have an office or you're doing business in North Miami, that doesn't mean you don't have to register. Everybody has to register. Is that your understanding, Inspector?
Good afternoon, Special Magistrate. Well, first things first, Rafael Padron, who is our business tax receipt specialist, he'll be able to provide more insight. But mind you, sir, I issued the violation on August 31st, 2023. It's been over 2 years. If he had any questions or if he ever thought that it did not apply to him, he could have reached out to myself or to the business tax receipt office in regards to clarification. But again, I'll pass the mic to Rafael Padron, again, our business tax receipt specialist.
Sir, is there, Mr. Padron, is there some exemption for businesses that are regulated by the federal government?
You're muted.
Sorry, no, Your Honor, not that I am aware of. The owner came in last week and expressed that once his type of business changed, he thought that he no longer needed a CU, and I told him that's irrelevant. He's registered on Sunbiz with North Miami address. His home base of operations is, in fact, his home, and he does need to have the business tax and certificate of use. The last time that business tax and certificate of use was renewed was for the 21 to 22 fiscal year. Essentially, it expired. They both expired September 30th, 2022. He was given his balance and informed what he has to pay to come into compliance.
Okay, so you're going to have to do it, sir. If not, the owner is going to get hit with a violation, which I'm going to give him a little bit of time because. And by the way, I think the owner should be notified of these things so that they can at least be aware that there's going to be ultimately it could be a lien against their property. But they chose not to come, and that's fine. I just take that into consideration when I issue my final award. Anyway, based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting and this is as to both the certificate of use and the business tax receipt, cases 31 and 32. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $350 until the violations are abated. That's to 31 and 32. So, sir, you go and speak to Rafael Padron at the city. He'll explain everything to you. You'll bring your, whatever paperwork is needed. Bring a check and, get this done. If there's an issue with zoning, with the certificate of use, you come back and we'll talk about it. And if you need like land use approval or something, we'll give you more time. But you got to have the permits to operate. And please be sure that the owner, your supposedly your landlord, is notified, because otherwise you may be in trouble with him. Okay, you're in violation of the city code. All right, let's move on quickly.
Miss, give me one again. Unlicensed room, which is the one who's been trying to speak throughout the previous cases. Sir, what case or what property address are you here for today? Can you hear me?
He's
hello.
Yeah,
He's 12201 Northwest 7th Avenue.
So this is cases from 7 through 11. I believe
yep.
so.
Yep.
So we'll be able to knock off a few, right?
Yep. Okay, so first of all, what is your name, sir?
What again?
Your name?
Oh, Fritz Gerald Gabriel.
Okay.
And how are you involved with these properties?
Owner.
You're the owner?
Okay.
What is your name again, sir?
Fritz Gerald Gabriel. Is the name of the corporation is a Scott? Let's Scott.
Oh yeah, okay, got it. All right.
Okay, so are you Gabriel Fitzgerald?
Yes.
Okay, so you're the president of the corporation.
Yes.
Okay, I looked you up. You're legitimate. Have you been sworn?
No, not yet. If you could please, thank you. Do you solemnly swear or affirm the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Thank you. I'm gonna go ahead and read the cases first, if you're okay.
Yes, please.
Okay, case number 7, site Lescott Group Inc. CER 2025-00190. Inspector for this case is Mr. Jonathan Lemestri. Case number 8, site Lescott Group Inc. CEBPR 2025-00191. Inspector for that case is Mr. Jonathan Lemestri. Case number 9, site Lescott Group Inc. CEBPR 2025-00192. Inspector for that case is Mr. Jonathan Lemestri. Site Lescott Group Inc. CEFOB 2025-00162. Inspector for that case is Mr. Jonathan Lemestri. And last but not least, case number 11, site Lescott Group Inc. CEGAB 2024-00001. The inspector for that last case is Ms. Shanna Sanders.
All right, sir, you have a number of violations on your property, which you have to fix. You have an improperly installed awning overhang. You have an improperly installed fence. There's some exterior renovations, windows and doors. You have a business tax receipt issue that you don't have a business tax receipt. You need to get a private waste collector with dumpsters and a dumpster enclosure. And so you realize that, right? This doesn't come as a surprise to you.
Yes. I'm working on the permits. I already put down on the certificate of use to the city. And those, because we was ready on the dumpster approval. We already finished the dumpster. Right now they already put down the permit. They fill out the application, and for the city to give them the approval.
You have a waste hauler on the contract?
Is they just get my email? They say they'll contact me for my email.
All right, you got Inspector, have you been in communications with the property owner?
I can't speak in regards to the waste. That's Shanna Sanders' case. But in regards to the awning, the permitted doors, and for the business tax receipt for the restaurant, Sealote's restaurant, I believe. No, I have not. Sealote's Cuisine for case number 10. I haven't been in contact with him, but he's aware. I've posted the violation with the North Miami Police Department. We did a business tax correction. I'm sorry. Every month, the North Miami Police Department and someone from our team, we do what we call a business compliance sweep. And one of the nights we did stop by to his residence and we gave him the violation in regards to the awning, in regards to the business tax receipt for the Sealote's Cuisine, for the illegal structure that's done at the property. So he's well aware of the violations.
All right. Ms. Sanders, why don't you weigh in on your violations?
Shanna Sanders, Neighborhood Service Inspector. This is the case for the sanitation violation for the private hauler. I have indeed been in contact with the business owner. I was the officer on the west side for many, many years, so I'm very, familiar with this property owner. So maybe he was comfortable with giving me a call. I did not realize we had all of these cases for Mr. Lemestre as well. He did, verbally inform me when I was hand delivering the notice to appear that he was working on other cases and other violations. I don't know. As of my last reinspection, compliance had not been met. The dumpster still remained in need of some repairs, and he had not secured proper waste services with Waste Pro at my last reinspection.
Okay, sir, how much time do you need to comply with all of these violations? Remedy them.
At least, the city take time to approve the permit. So at least I could say 3 months.
No, I'm not going to give you 3 months. I'm going to give you 60 days. Because, there's just too much neglect, and some of this stuff can be done relatively easy, like getting a fence permit or an awning permit. And hiring a waste hauler should not take you 9 months to do. So I'll give you 60 days, and we'll see where we are then. Okay, based on the testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city and enter an adjudication as to all of these cases. Each individual case, same order, compliance date of December 3, 2025. In the event of non-compliance, there shall be a daily fine of $350 until the violations are abated. So after each violation, you got 60 days, $350 if you are not in compliance as of that date. In case of an emergency, you can talk to the inspectors. They'll try to help you through the building or permitting process. And if you have an emergency, it'll come before me and then I'll rule on it. But right now you got 60 days. And so we've taken care of quite a few cases in one shot. Okay, Madam Clerk, I have 5 minutes. So you tell me if you have cases you want me to rule on real quick.
I have case number 5. BCBG LLC CEFLR 2023-00446, found guilty by Magistrate Casso, Masabai by April 18th, 2025. Fine set at 150 plus 150 cost assessment. Inspector for this case is Mr. Jonathan Lemestre. It's just a matter of ratifying or not, Magistrate.
All right, are they still, Inspector, are they still not in compliance?
Correct, Magistrate Smith. So this business is at a strip mall. I spoken to the property management team at the strip mall, and they informed me that the owner still pays rent, but she hasn't been operating at the location for a while, so I don't know what's going on with her. But the business is still active on Sunbiz.
And they're still there?
They're still there.
Okay, well, either the ownership is going to have to evict it or pay the fine, you know, for the business. But if they're still doing business there without a business tax receipt in violation of the magistrate's order, I'm going to go ahead and ratify the fine based on the unrebutted testimony of Inspector Lemestre. The photographs and the evidence presented showing that the property has been out of compliance since April 18, 2025. I find in favor of the city, hereby ratify the fines accrued to date in the amount of $150 and assess costs in favor of the city. The fines shall continue to run on a daily basis until there is compliance. Let's take one more case, and then we're going to have to roll the others because
okay, case number 12 and 13 have the same property owner, and it's just a matter of ratifying. Would you be okay with that?
Okay.
Case number 12 is Crystal Bay Investment LLC, CEFOB 2023-00499. Found guilty by Magistrate Casu, must abate by September 15, 2025. Fine sent at 250 plus 100 cost assessment. Case number 13, Crystal Bay Investment LLC, CEZCU 2023-00827. Found guilty by Magistrate Casu, must abate by September 15, 2025. Fine set at 250 plus 100. The inspector for both cases is Ms. Shanna Sanders.
Shanna Sanders, Neighborhood Service Inspector. If I can, before you ratify these fines, Mr. Padron, are you still there? Is this the case that we spoke to, that I walked the gentleman over there for his father? Me, you, and Gary spoke about this. You said he submitted the application.
I was disconnected because Zoom crashed. So what case are we on?
This is 13 and 14. No,
Yeah.
12 and 13.
12 and 13.
12275 Northeast 6th Avenue. I just want to make sure, because I think this gentleman came in 2 days right after the hearing. He's been submitting the applications and stuff or whatever. When you jump in, Raphael, you can. I just want to make sure, is this the one where I walked the gentleman over with his son?
I don't remember. Let me see if I can look up the account real quick, because like I said, I was disconnected and the whole thing froze.
I don't want to ratify these fines, Magistrate, because he has been working with the city. He submitted them, and it's been sitting on someone's desk for a couple of weeks. We just got it moving, the application, I believe, about a week or two ago, when he came in asking what's going on. I see you cited me again or gave me notice or something to that effect. I believe
we do have an application in the system. So he has, yes, I believe this is the one that we spoke about. So he has been attempting to come into compliance.
Yeah.
It's just going through the process.
Yeah, so if we can, I don't mind granting him more time, because it's been sitting on someone's desk for over a month. He came right after the August hearing. I believe he said the 8th and submitted it, and it just didn't get moving until I think a week or two ago.
Okay, this is a condo association, so who is the he that we're talking about?
I believe he was, he may be the manager, he might be the condo board. I don't remember exactly. I believe he said he was the property owner. It could have been. His son came in, and I spoke with the gentleman over the phone. He said, he was out of town, this, that, what have you, but he was sending his son. And his son came over as promised. We walked through everything. And,
I noticed you wrote apartment building, not a condo building.
It might be an apartment. It might be an apartment. Because I remember it's 3 separate buildings there. But I'm gonna just say I believe he was the property owner or either the manager of the business.
Okay, and this arose out of an annual housing inspection.
More than likely, yes.
Yeah.
For me to
Yeah,
have been in that
I
area,
noticed.
yes.
I noticed that. So let's table this for the next hearing and see where
Okay.
we're at. If
No
they're in
worries.
compliance, then don't bring it back. But if they're not, then bring it back.
Yeah, because I believe his last conversation it was with Durham. So yeah, he's working on it.
Cynthia, how many more cases do we have approximately?
Like 17.
17?
So all those will be tabled to the December hearing with you.
Yeah, if if there's any one of those 17 that you need me to act on, I can take one more case. So pick whichever one you feel is the most important.
No, I believe the ones that were the most important, we already heard them. If I'm not mistaken, I don't know if any of the inspectors.
I'll jump in with mine. You know, these BTRs, especially while we have Raphael here. 1955 Northeast 149.
What's the case number?
What's the case number?
CEFLR.
No, case number.
Case number.
On the agenda, what number is it?
Agenda. Let me see.
Cynthia, be sure to have enough time so that when you're tabling the others, you can put it on record.
Yeah, absolutely.
25 and 26.
Okay, let me go see.
I'm gonna get rid of mine.
So case number 25, NMB Partners LLC CEFLR 2025-00078. In case number 26, NMB Partners LLC CEZZU 2025-00237. Inspector for both cases is Ms. Shanna Sanders.
Shanna Sanders, Neighborhood Service Inspector. First case for CEZCU 2025-00237. They kind of go hand in hand. One is for the failure to obtain and or renew the certificate of use. The second one is CEFLR 2025-00078 for failure to obtain the business tax receipt. Both of them are for business names Synergetic Services Inc., whereas I initially cited this property and did an inspection on the property on 7/23 being July 23rd, 2025, whereas I got a notice from Waste Pro about services, the sanitation services not being paid in, or they had an outstanding balance. At that time, while doing an inspection, I went ahead and said, let me take care of everything there, ran their license. At that time, I saw that it needed to be renewed. I had a conversation with the property owner at the property, as well as I then got on the phone with Mr. Padron, because the property owner stated that he thought he was up to speed and was in good standing with the city. We brought to their attention he wasn't, we told him how much was needed to be paid. As of my last reinspection, the business tax receipt nor certificate of use were renewed. I am showing proper service was given. I myself hand delivered the notice to appear, and certified mailing was mailed out on the 9th. I see Mr. Padron raising his hand. Again, I did contact him at the time of doing the inspection when I initially cited in when I did the reinspection, because again, the business owner thought he was up to speed and in good standing with the city. Go ahead, Mr. Padron, with your testimony.
As of September 17th, they're in compliance.
Okay, so he paid. There we go. Okay.
That's it. That one's done. I don't want to interrupt you, but at the same time, I know, I tried.
By the way, I don't know whether it matters, because you probably did the good service anyway, but you have a notice of posting.
I noticed. I noticed it.
Holland Beach Boulevard. Okay?
You're always on top of it. I noticed it. I said, we're going to slide that one on in.
Yeah, but, no. I read everything.
So both cases have been closed then?
Yes.
25 and 26? Understood.
Okay.
Thank
Does
you,
anybody really need something heard? Because I really need to go.
Jonathan, do you have anything as an emergency? Because all the rest of the cases will be postponed to the December hearing. We can hear you, Jonathan. All I see you is just shaking your head.
All right, cases 16 and 17, Miami Vibes Hostel, 1230 Northwest 135th Street, case number 16 important. And case number 17. So very quickly, this is in regard to a business tax receipt and certificate of use. They were found guilty by Magistrate Smith, and they had to abate by May 16, 2025. Fine was set at $350 plus $100 cost assessment. As of the final reinspection, the business is still operating as a hostel. They're advertising on as a hostel. You could go on Expedia, Google Maps, wherever you could think of for a hostel, for search of a hostel. It's still being advertised as a hostel at the location.
Okay, I saw that. I don't like this type of operation, especially without a business certificate of use, or I don't even know whether they would qualify if it's a single family neighborhood. I don't know if it is or not. Nonetheless, I did enter an order, which by the way is not on file. So please, in the future, make sure that all orders are part of the file. So as to 16 and 17, same order. I will ratify the fines based on the testimony of the enforcement inspector and the evidence presented, including detailed evidence of operating a hostel. Property has been out of compliance since May 16, 2025. I find in favor of the city and hereby ratify the fines accrued to date in the amount of $350 on each case. And assess costs in favor of the city. This fine shall continue to run on a daily basis until there is compliance. And with that, folks, I've got to run. It's been a pleasure.
Thank you, Magistrate.
Whenever
Good luck
you get
in
a
your
chance,
meeting.
whenever you get a chance, Cynthia, in the next couple of days, if you could give me a call. I would have normally asked your boss, but he's not available. So if you could give me a call, or I'll call you and we'll discuss.
Absolutely. Yeah, I'll call you. Absolutely.
Okay, not tomorrow,
Thank you.
though.
No, I won't call you tomorrow. I promise.
Tomorrow.
Thank you, Magistrate. Good
holiday.
luck. I know. I do. I am well aware of that. Thank you.
Okay.
Good luck in
All
your
right.
meeting.
Thank you, and I'll see you all next time.
I'll talk to you soon.
Bye-bye.
City Attorney, do you want me to read all the cases that have been tabled on camera, correct? Yes? Okay. So case number 21, Josephine 1 Corp. CEMDU 20240015, found guilty by Magistrate Casu. This case has been tabled to the December 3rd meeting. Case number 27, Perline R. Turner and CEBPR 2025000231 has been tabled to our December 3rd meeting. Case number 29, RARO Investment Trust, CEFLR 2023000454. This case has been tabled for our December 3rd meeting. Case number 33, RARO Investment Trust, CEZZU 2023000863 has been tabled to our December meeting, December 3rd, 2025. Case number 35, Roger Bay LLC CEBPR 2023000823, found guilty by Magistrate Casu, must abate by January 17, 2025. This case has been tabled to our December 3rd meeting. Case number 36, Rosenthal Enterprises Ltd. CEFLR 2023-00468. This case has been tabled for our December 3rd, 2025 magistrate hearing. Case number 37, Ruben E. Ledesma, CERCB 2023-00379. This case has been tabled for our December 3rd magistrate hearing. Case number 38, RUDG LHHA Bell House LLC, CEFOB 2023-00461. This case has been tabled for our December 3rd magistrate hearing. Case number 39, RUDG LHHA BEL House LLC, CEZCU 2023-00784. This case has been tabled for our December 3rd magistrate hearing. Case number 40, Sailboat K Condo Association, FYBRR 2023-00021. Previously found guilty by Magistrate Smith, must abate by June 20th, 2024. Fine set at $350 plus 100. This case has been tabled for our December 3rd, 2025 magistrate hearing. Case number 41, Scott Andrew Gallia LLC CEFOB 2023-00476. Found guilty by Magistrate Casso. Must abate by September 15, 2025. Fine set at $250 plus 100 cost assessment. This case has been tabled for our December 3rd, 2025 magistrate hearing. Case number 42, Scott Andrew Gallia LLC CEZCU 2023-00800. Found guilty by Magistrate Casso. Must abate by September 15, 2025. Fine set at $250 plus $100. This case has been tabled for our December 3rd, 2025 magistrate hearing. And that concludes the end of our agenda for this October 1st, 2025 magistrate hearing. Need anything else, Madam City Attorney? We're good. Thank you. I appreciate you. Have a great day.
Have a great day. Thank you so much.